Okay.
So everything's going. I realize we're 5 minutes ahead, but
Yeah, we're 5 minutes ahead.
I want to make sure everything's working.
Good.
Good plan.
It's kind of like starting your mower up after sitting all winter, right?
Right. I mean, the last thing I want to do is then Charlie says, let's go. And I say, okay. And it doesn't go.
Flat tires and dead batteries.
Two of them. One of them died in the middle of mowing.
Oh, really?
The Lord riding lawnmower died in the middle of mowing the front yard.
That's not good.
And the other one wouldn't start. So now I have an half mowed front yard.
And the dead person.
Huh?
The dead person. So somebody died.
His lawnmower.
My lawnmower.
Always the person.
Well, he's pretty attached to that lawnmower. My goodness. You've been busy.
This is the,
Just, I think mainly all ours. You just send out if you want those printed out.
Yeah.
Taxpayer
Sure.
minutes.
Here was the stuff we talked about. Is if I was confidential.
Are you doing that?
Yes, I can. Are y'all ready?
In just a minute.
3 minutes. So we did not
This-
include the.
this is,
Cindy doing?
It's good. Good. We didn't include the. Good, yeah. It was interesting. It was a month,
this may be.
2 months.
Yeah. It's at the very.
2 months. Oh, no. We stayed for a week and it's kind of been talked about.
It's also in there.
She did all the tests that lead up to
Thing,
the
so
thing.
we just need to say.
And then at some point, it would have done all the tests and determined that she
Clarification.
passed the test.
Yeah.
So
The items that relate to.
we checked into the hospital and then we were sequestered for 2 weeks.
Okay.
While they were on the same floor, never stepped outside. Never left. I've never done that my whole life. It's like,
Yeah.
like
Yeah.
prison.
Yeah.
You order it like room service and they deliver it. It's really pretty good. It's not hot. It's very good. And you can use Uber Eats and all that.
Okay.
Which I've never done before.
Okay. So did she find a bone marrow donor? I mean, she couldn't meet one of it.
They use their own.
Oh, okay.
It's called.
Okay. Call to order the meeting of the appraisal review board for the Aransas County Appraisal District. It is November the 1st at 1 o'clock. We have a quorum?
Yes, Mr. Chairman, we do.
We have everybody. First up is the approval of previous meeting minutes.
Oh, okay. Should be there on the docket, on the tablet.
What is it?
Approve it, but if it's not, we'll get it on there. We thought we probably want to just go ahead and start with the hearings and take that in a different order.
Okay.
And in regard, I do have a question for the 1 o'clock hearings. Mr. Falk called this morning, said he had just gotten out of the hospital, had a medical issue. And I asked him to write a letter to the board requesting to be able to phone in and or Zoom in. Here's what he sent. He said, Val, I apologize for the delay. Attached is the form 50-283 and attached evidence. Please let me know if you have any questions and with what number or video link I can participate remotely in the hearings this afternoon. So I don't have an actual request from him, but he would like to participate by video.
And which one is he?
He will be for all 4 of the hearings on the 1 o'clock docket. He is the agent attorney for those cases.
Okay.
So we're doing the 3 o'clock docket now.
No, 1 o'clock.
No,
The
you said
1
he
o'clock.
was the 1 o'clock.
Yeah.
He is the 1
He
o'clock.
is
He's the representative, representing the client.
Right, and he wants to come in.
And the district does not object to them appearing by Zoom.
Okay.
We're okay with
Do we have any problem with that?
Okay, so I will make a call to Mr. Falk give him the information, and then while I'm doing that, we could go ahead and do the minutes. We'll make sure we pull them over into the drive.
Okay.
So are we doing Zoom now or at 3:00?
Well, no, the
As soon as she
Zoom,
gets,
the Zoom is at 1 and it's for 4 or 5 accounts. And, but according to what she just read, he didn't look at, because you know how the says you can appear by this. or you can appear by
Yeah.
that. It's in there, but he didn't look at it. So we're gonna give him a call, tell him he can Zoom in, you know, up until today, he was planning on being present.
Okay.
He's not present. He's been, you know, again, he had some kind of medical thing. Well, yeah, he didn't feel safe driving because he had some kind of thing. So anyways, we don't object. He can have it.
So leftover Halloween candy.
Yeah, no, actually, it's kind of fresh, but, yeah.
So, get rid of it.
Save us from ourselves.
Scott, you can see the evidence of Scott, because Scott has just all these wrappers all around. We did this deal yesterday, you know.
If you listen closely, you can also hear what it is he's
We
eating.
had to set up like a big bucket, and we had all this candy and toys down below, and then you had all these like big balls and on top of it, and they had to scoop down in there and see what they got. And man, you should have seen their faces. They come up with all this, and I'm like, oh my gosh, that's too much. Like you can't put all that. They just dump it in their face. And then other kids are just like, they come up with 1 or 2 candies, and I'm like, okay, let's do this. Do it a little harder, you know, like let's get you something.
Did you have a lot of kids?
Oh man, we had like 150 kids.
The
over
minutes
there.
are
Yeah,
uploaded, and
yeah,
there's a
over
copy.
at Coastal Oaks, yeah, it was
Okay.
good.
Where did you do it, at your house?
Coastal Oaks, yeah. Yeah, it was a
Oh.
trunk or treat.
minutes are up there.
I think they still have the best youth program.
Okay,
It was a lot of fun.
so we'll take the minutes of the, I guess it's.
Minutes to be
one
approved.
meeting, just the October 7th meeting.
Now on your tablet, minutes to be approved.
There we go.
Yeah. So if you will go on to our website.
You don't see anything that's a problem?
No, it all sounds good. That's good. I make a motion to approve the minutes, the October 7th, 2021 meeting.
I'll second.
All in favor?
Aye.
Done. Is he in? Yes, sir. You doing yet?
I think Val's on the phone with him right now.
Do we want to read, this is the, okay, got you for the, oh, there's only 3 instead of 4?
Well, he's got the one and the other one. Arnold. Has his own.
Got you.
Yeah, you don't.
Jim, do you need a sworn affidavit?
I'm not gonna get past it.
Okay.
There's 3, not 4.
There's 3 individual and then 1 is the company.
Okay.
my desk. There's a.
Yes, sir.
Mr. Falk, can you hear us?
I can, you're a little muffled, but I'm also putting on an aftermarket speaker here. That should assist.
Okay, we're
All right.
doing. He's representing the three. The group of three.
Mr. Falk.
Yes.
I think all,
Now it looks like you're all in on the Zoom.
Thank you so much.
Okay, bye-bye.
you can ask him. But I believe.
Okay, sir, do you have 4 cases or 3?
I believe 4, but I am happy to, I would like to dismiss upfront a protest on the valuation of, it was 57 Nassau. Since filing that protest, the property has been conveyed.
Which account number is that, sir?
It's for 57 Nassau. Let's see.
24720.
I don't know. This other one's Keeler Rosewell. That's why I'm asking which. Oh,
This is 57 Nassau.
yeah, 24720. You're withdrawing. Is that correct?
If that is 57 Nassau, then that is correct. Let's see. All right, yes, sir, 24720. To be withdrawn.
Okay. In that case, we'll get started with the other 2. Account 55117 and 54798. And bear with me while I go through a script that's required.
Yes, sir. Would it be possible to begin with the homestead exemption issue at hand first?
Which one is that, sir?
That is related to 914 Latrone.
54798. Okay, we'll get to that one first.
Okay.
No problem.
Yeah. So just so we're all clear, there's 3 remaining properties. 2 are in the name of Bruce and 1 is R&M Properties. Is R&M Properties, that's just a value dispute. Is that correct?
Arnhem Bruce Properties is over
On 3036.
FM 3036. Yes, sir, I do believe so, but there's, I guess you'd call it an outstanding issue regarding 2020's homestead exemption, subject to the conversation regarding 914.
And we'll start with 54798, and it's related to 55117. You'll see
Okay,
based on the protest.
okay. All right, bear with me. This hearing is being recorded. What's on the protest?
It is for this one.
Oh, for 54798 first.
It is Q6, exemption was denied, modified, or canceled.
Okay. We're the appraisal review board that will be hearing your protest today. We do not work for the appraisal district. We are appointed to perform an independent review of your protest. The review board, if you can see us, are around the table here. There's the 5 of us. Mike is the representative of the appraisal district. He has his lawyer with him,
Jim Evans.
Jim Evans. And Scott is working the computer. At the end of the hearing, you may complete a survey regarding your experience. The survey may be completed using the survey form and emailed to ptad.communications@cpa.texas.gov or online at surveymonkey.com/r/survey-ARB. Survey is voluntary. You also have the right to appeal our decision. Appeal information will be provided to you with our determination. In accordance with tax code section 4145H, all written material that has not been provided must be provided at this time. This is important. Do we have all of your evidence?
I do believe so. Was the evidence packet that was submitted to Val made available to everybody?
Very good. Yes.
Wonderful. Thank you. That should be it.
ARB members who are considering the protest have not communicated with anyone about the protest or signing an affidavit to that effect. I, Charles Powers, do solemnly swear that I have not communicated with another person in violation of tax code section 41.66F. And that is currently related to case number 141, case number 2240.
I, Robert Dayton, do solemnly swear that I have not communicated with another person in violation of tax code section 41.66F as it pertains to case number 141 and 2240.
I, Kathy Hoffman, do solemnly swear that I have not communicated with another person in violation of tax code section 41.66F in relation to accounts
141.
141 and
Collect audible.
224.
Middle one was withdrawn.
I, Bill Duck, do solemnly swear I have not communicated with another person in violation of tax code 4166F in reference to cases 141 and 2240.
I, Scott Wagger, do solemnly swear that I have not communicated with another person in violation of tax code section 41.66F pertaining to case number 141 and 2240.
All testimony from all witnesses must be given under oath. Do we have an affidavit?
We have an affidavit.
We have an affidavit on file?
For the subject property owner.
Okay,
Owner's agent.
Yeah,
and it's on
okay.
file. And as a district representative, I do solemnly swear affirm that the testimony shall present to the appraisal review board for the Aransas County Appraisal District is true and correct. Michael Soto.
What can he see?
He
Can't
can
see the
see,
wall.
he can see this, he can see this.
He can see all of us here.
He
Yes.
can't-
He's been given,
Do you have in your possession the procedures document, the times for the hearing? It's-
I do not, just the model ARB hearing procedures.
So you don't have the chart that shows the time, presentation, cross examination, that sort of thing?
I do not.
Okay.
We'll walk you through.
We'll walk you through it
Too
as
easy.
we go. Because I don't know of any other way to get it to you at this point.
Okay.
I will say.
So do you? Go ahead.
Yeah, I will say that in this particular set of two, that I'm just gonna say that this is probably going to well expand the timeline that you're normally accustomed to. For that reason, there's one property owner or property owner's agent, and there was only 4 cases, and now there's only 3 for the entire 1 to 3 o'clock docket, because I know that this was a not normal situation. And therefore, I, as the district representative, am affirming to you that I'm okay with an extension of that timeline.
Okay, well, in any case, you should have an email coming in that has the page that we've been referring to. Now, the question is, do you want to speak first, or do you want the district to speak first? You have a choice.
I would like for the district to present their case first.
Okay.
Ladies and gentlemen, may I proceed?
Wait a minute. Did he?
He's not giving testimony.
No, just for the record, my name is Jim Evans. I represent the appraisal district in this matter. I'm counsel for the district. I'm not going to be giving testimony. Testimony will come from Mr. Soto. I'll be making arguments to the ARB, asking questions, but I will not be providing testimony.
All right. That's a fine line.
You know,
Why does it matter that you swear in?
Well, there's also a disciplinary rule and the rules that govern my profession that look down on attorneys giving testimony, except for things like attorney's fees or preliminary matters. There's nothing substantive here. The facts known are known to Mike. So Mike is better qualified to give factual testimony than I am. I'm not going to talk about the facts on the ground. I will give the ARB legal argument, which of course does not need to be sworn to. And if I'm asking Mr. Soto questions, I don't need to be sworn to ask questions. It's kind of like being in a trial where the attorneys are not put under oath, but they're still entitled to make argument to the court, argument to the jury, and then ask questions, things of that nature. So I prefer not to sign the oath because I'm not going to give testimony.
All right.
If you catch me giving testimony, give me the oath and I'll sign it. But
Okay.
I won't be.
Fair
I don't
enough.
anticipate that I'm doing that.
Go ahead.
Like I said, for the record, my name is Jim Evans, of the firm of Lowe, Swinney, Evans and James. I represent the appraisal district in this matter. In this particular case before the ARB, there was an issue about whether the property known to the district as PID 54798, also known as property at 914 Latron, was entitled to a homestead exemption in 2020 for the tax year 2020. I'll state for the record that the property owners had an exemption for that property in 2020. The exemption was removed by the district, and that's the reason why we're here at this point. At this point, I'd like to ask Mr. Soto some questions subject to cross-examination by Mr. Paul. I've concluded my question. Mike, you're the chief appraiser for the district, is that correct?
I am.
And are you involved in this question about whether the property at 914 Latron is exempt under the homestead exemption?
Yes, I'm involved with it.
Now, for 2020, what was the property at 914 Latron valued at? What was the appraised value for that?
Have to look in the evidence, but
Was it about $34,000?
$34,900, yeah.
Okay, and is that number higher, lower, or equal to the sum total of the school tax exemptions at the property for 2020?
When you consider both the homestead and the over 65, it's the sum total just shy of the sum total. So the summation of the two is a 25 plus a 10, which is a $35,000 exemption. This subject property is $34,900 in the year in question. Furthermore, I'd like to add that this was a late application in the year of 20. So it's not it's received in the normal course of business, but not at the normal time that a person would apply for an exemption.
Mike, to the best of your knowledge, did Dr. Bruce turn 65 in 2020?
According to his driver's license, yes.
Okay. And then after the homestead was qualified at 914 Latron, did you learn that the Bruces were applying for a homestead at 2662 Farm to Market Road 3036?
That is correct. And to expound on that, the Bruces had long since, or in years previous, had a homestead exemption on 3036, a house valued for much more in the $300,000 range. That we could look to see what exactly that figure is, but they had an exemption over on 3036. They then applied late, and when I say late, in May of 2020 for an application of January 1, 2020 at this 914 Litron. So they applied for a homestead exemption on this mobile home, after which they had an exemption previously for a number of years at this other house. And then the follow-up, what was the last question? The last question was?
The Bruces applied for an exemption.
That's correct.
Later at 3036.
So later in the year of 20, they wanted to remove their exemptions and put them back on this other property. At which time there was a red flag to, okay, there was an exemption removal, exemption late application for a mobile home, and then a wanting to go back because they were 65, they wanted to apply what's called a homestead exemption freeze on the other home that they just vacated or said that was no longer the residence on 3036. This is kind of the circular thing that's got me into the, hey, there's a red flag, was this ever really your home thing, and on the mobile home itself. And therefore, I've denied the mobile home exemption. Denied the homestead exemption associated with the mobile home because I don't really know if the subject property owner really vacated the property in totality at the 3036 location. So here we have like a kind of a moving target, as you will.
So let's clarify the facts a little bit. The house at 2662 3036 was owned by the Bruces in 2019.
In which location?
The house at 3036.
The house at 3036 has been owned by the Bruces since 2017.
And do they own it?
Actually, since 2000. Well, let's see, Bruce. I see 2004, and then Ashburnair. Oh no, this is not the. I'm sorry. Let me get the exact.
They own it prior to 2019.
Yes, they owned it prior to 2019.
And then did they own it in 2020?
Yes.
And they own it in 2021?
Yes.
So to the best of the district's records, best of your knowledge, the Bruces have never sold the property at 2662 Farm to Market Road 3036.
That is correct. They've owned it since 2012.
All right.
They've owned the house on 3036 since 2012.
What
They lived
is,
in it? They lived in it during that time?
I'm
They
sorry.
lived in it during that time?
we're fixing to get into
Yeah,
that.
yeah, we're about to.
The for 2020, Mike, what was the appraised value for the house at 2662 Farm to Market Road 3036?
I have that information, I think here. It was, I don't have it, let's see, it's approximately,
Was it about 405,680?
yes, that's what I have.
And would a person who is over 65 have to pay taxes on property with that kind of appraised value if it's their homestead?
They would, in fact, the calculation for the appraised value and the freeze associated with that type of home would be above the number of the 468,000, or above that $400,000 number, less the exemptions or less that 35,000, and then they would freeze at that amount. So there would be approximately a $400,000 taxable value that's there, and then that would count against the tax rate and create a levy associated with each school district.
So to pare this down a bit, Mike, if they lived at 914 Latron and it was their homestead, would their tax bill from the school district be zero?
Yes, if they actually, if a person, and specifically the Bruces, but if they lived in, at the Litron property and they continue to live at the Litron property, their tax bill for the school district would be zero, because the sum total of the 34,900 would be just under the threshold of the summation of the taxation or summation of the exemptions of both the homestead and the over 65. Any person, for that matter, that has a property within this county that's less than 35,000, and if they lived in a property, they would receive a similar tax bill.
Now, let's talk about portability of an over 65 exemption. Is it true in the tax code that if a person who is over 65 establishes a new homestead, then that person gets to take the percentage of the exemption from the old homestead to the new homestead?
That's correct. And that calculation of what's called a homestead tax ceiling certificate is a calculation of a ratio that's applied throughout the state, meaning that if a person lived in Fredericksburg and their taxable freeze was calculated at a certain rate, that rate is calculated on a differential between what a person would receive if they didn't have the exemption as opposed to what they had paid as a result of their over 65 exemption. And that's done throughout the state. So people from Fredericksburg come down here and they say mine is 68.9%, and we send people away, and we actually send out tax lien certificates to other locations within the state. It's portable for the school district within the state.
So they get to move the same percentage of the taxes they're paying from one residence to another.
That's correct. And in this particular case, if they wanted to port anything, a port would indicate a value of 0. The calculation would indicate a value of 0. This is where the red flag came in to me, because usually it's a 2-year test. The reason it's a 2-year test is you take the lower of the 2 levies in any 2 congruent years or adjacent years in which a person turns 65. So you can find out the levy, and then you take the lower of the 2, and that's what you port, or that's what you would transfer free ceiling certificate out. That's where the free ceiling actually comes in play. In this case, because the person that's applying for the exemption that wanted the tax ceiling certificate at 0 had not even calculated 1 calendar year, it threw up a red flag to me to say, well, this can't be, like, you can't move, you don't own this house right here and then move it to here and then go back to here, well, all within the same calendar year. Like, you don't get to, there was a red flag coming off. And therefore, there's an idea that, at least from my standpoint, it gave concern that the owners of both properties were not, they really didn't vacate the other property. Again, that's my claim, that they didn't vacate the other property.
So to recap, then, if a person who has a homestead that's worth less than the sum total of over 65 school exemptions, pays a school tax of 0, and that person moves from that homestead, that person continues to pay 0 for the rest of that person's life, regardless of how valuable the new place is?
That's correct. So if a person that in this case was under 35,000, the place that they claimed as their homestead number 65, let's say that they're in that home for a period of more than 2 years, because I talked about the 2-year test, that person could then buy a property somewhere else in the state for $750,000 and take the free ceiling certificate of 0% and apply it at that other school district. It could be within the same county.
Now, so the facts, as you understand the facts and the documentation with the district, are basically this. In 2019, did the Bruces have a homestead at 2662 Farm to Market Road, 3036?
Yes, they had a homestead exemption on the 3036 house.
And then in 2020, did the Bruces eventually apply for a homestead exemption at 914 Latron?
Approximately May of 20, they applied for a homestead exemption in 20 at the 914 Latron.
And then in 2021, have the Bruces applied for a homestead exemption for their old property at 2662 Farm to Market Road, 3036?
That is correct. They have applied, for which I have not.
Is it your belief that if the appraisal review board disagrees with the district and provides a homestead for 2020 for the Latron property, that the Bruces pay 0 school tax on the 2662 Farm to Market Road 3036 property for the rest of their lives?
Yeah, they pay 0 school tax without any additional freeze, any addition to the freeze, which could result from, and this is true for anything. So if a property, in this case, if property owner froze at 0 and they added something new to that property, then that would be an additional to the freeze. But Otherwise, that's a true statement. They would pay zero school tax.
Would you look in your records and tell the ARB, what is the square footage of the house on 2662 Farm to Market Road 3036?
Let's see if I have that one. We have approximately, let's see, we have a 2,996 main area square footage. And we also have a garage of 596 square feet. We have a couple of porches, storage, and awning. We have an additional out warehouse of 2,880 feet. And again, the value in 2020 was 405,860 for that home on 3036.
We'll pass the witness.
Okay. Sir, you have cross-examination and presentation, your presentation.
That's correct. Let me see. Just real quickly, do you, when you see any transfer for a homestead exemption in Aransas County come into your office, do you conduct an investigation to each one of those transfers, or just simply folks who you described as a red flag, just simply folks who are 65 years and older, right in that age range?
No, I do investigations of homestead exemptions and all kinds of applications all the time. They have to do with things that are called accurate, which is a sourcing data where it has to do with where's a person's actual situs. So I do those all the time in relation to homestead exemption applications. I also have the oversight and purview of granting religious property organizations, other non-charitable organization applications. All of that is under my purview. When I have a question, I then source my legal counsel in any cases that are outside of the normal. So we process many applications, and yeah, I look at them all. The timing of which is they're congruent with different times of the year, meaning that sometimes even now we're receiving late applications, and whenever I receive late applications, there's a higher level of just like looking at where is this person moving from? Do they still have a homestead application in Bexar County? I need to look at all of those things before I grant it here. Those are those types of things. When I receive it earlier in the year, congruent with January of any given year, we're doing those same types of checks, but at a different time of year. The time that this was received was in May, which is the protest season, as this ARB well knows. And the focus is not looking at those homestead exemptions. The staff member that looked at the application looked to make sure that the applicant was applying for the same property in which they had the driver's license, and in fact, that was the case. So,
right. But so they did get an application. They processed the application. It's all under your purview, as you said. Was the paperwork properly in order and filed with your office? And was that why that there was granted an approval for the exemption for 2020 for 914 Latrone?
Again, I would say that it wasn't filed in the normal course of business. It wasn't filed timely in my opinion, because
it was during COVID, right when it first kicked off, was it not?
The subject property owner claimed ownership at Latron on January 1 of 2020, and I didn't receive an application until May of 2020. So it's not typical. I would say it's not typical, but I will say that the driver's license that was submitted with the application did match the 914 Latron property, and therefore it was granted at that time. The red flag, as you indicated, didn't really pop up until they were trying to apply that it didn't occur until they were wanting to reapply for a homestead exemption for the property they still own. And therefore, when I looked at that, I was like, hey, this is not normal.
Okay. So, but just to be clear, they did submit the paperwork. Your office did process that paperwork. Your office did grant that exemption. And then it was, say, a year later, a little over a year later, that there was a determination made that you weren't sure if there was a proper homestead exemption applied in the year 2020 to that property.
It wasn't a year later. It was several months later. only a few months later, actually.
Are you familiar with the date when the first notice went out that you weren't sure if that was their primary residence?
I don't know that I have that in front of me, but I do know that it was congruent with an application of, or at least a question to our office of taking the exemption back to the 3036 property, which was in the fall of 20.
Okay. Have you, when you went ahead and removed the exemption for 914 Latrone for 2020, did you reapply it to the 3036 property for the year 2020?
No.
Okay, so do you not believe that that property was the, I'm just a little confused as to what the argument was, if it's your belief, although I haven't heard, other than the tax bill went down, any articulable reason why you believe that they weren't living at 914 Latrone. Is it then your belief that the 3036 property was their primary residence in 2020?
No, I don't know. I do have evidences for both that's submitted in my evidence packages for cars being at both locations in and around the first. So I don't know.
Can you identify any of Dr. Bruce's vehicles on that property on 3036 around the first?
I'm not an investigator like that. I just.
Okay. I only asked because I reviewed them and didn't see any vehicles belonging to him in those photographs. Just simply a vehicle belonging to his son, Stuart Bruce.
Okay.
So I just didn't know what level of investigation you had done there. Because also just earlier you had stated that you didn't know if they had vacated that property and that's why you denied then the exemption on the backside, or you canceled it. Did you try calling Dr. Bruce just to ask, to figure out what was going on there if you had a curiosity, or did you just decide to cancel the exemption?
Yeah, I don't believe I've had a conversation with Dr. Bruce.
Okay.
And of course, he's not on the Zoom today for me to cross-examine him, and that's convenient.
Sure. I'm just trying to figure out early on how we got to a cancellation.
Okay.
I mean, you can see where I'm going with this. I've heard no other articulable suspicion other than a theoretical their bill would go down as to why it is that you don't believe that he was being honest when they properly filed that paperwork, which is granted for an exemption on the 914 Latrone property in 2020.
No,
I haven't heard any reason other than their tax bill would go down as a theory as to their subjective mindset.
I'm looking for the subject property owner to tell me where he was on which and which dates, because to the best of my knowledge, I've had a conversation with people that live next door to the 914 Litron.
Did you submit any of this information with the packet of information? I haven't heard about any of this.
I can give testimony to the conversation that I had. Can I not? Sure. Of course. So I've had a conversation with somebody that lived next to 914.
Well, I can't cross-examine this other individual. I mean, this would generally be impermissible unless there's some kind of, government recording,
This is being recorded.
Yeah, and
No, I mean, a recording of this conversation. Otherwise, this is generally what would be considered hearsay. I mean, I'll defer to opposing counsel here, but typically this wouldn't be allowed in a proceeding unless through an exception.
question.
Yeah, the question that was posed is like, he's heard no other evidence, and this is just one of many evidences that we've presented, one of many evidences. It's the most clear-cut illustration of what I believe happened in and about 2020 and 2021 as it relates to the Bruce's application processes. Both of them.
Can't you relate that conversation you had with the next door neighbor?
Of course I can. And answering the question, I certainly can.
Go ahead. This is their time.
Well, he asked the question, I get to answer the question.
Yes.
So in answer to the question of the 914, the adjacent property owner, I said, do you know anything about the Bruces who live next door to you? Yeah, they were fine people. They were in there for a little while. But I said, were they in there all year? No, they weren't in there all year. There was other people in that mobile home that were living there towards the end of the year.
Yep.
So they were.
Let's go to that, Mr. Soto. I have provided everybody with an affidavit signed by both Dr. and his wife, Melissa Bruce. Now, it kind of breaks down the situation because you're correct. In fact, they were not there for a year.
They were not, is that what you said?
That is correct. And I've also provided bills that suggest a rough estimate of the amount of time, but that's also discussed in that affidavit. And I think it might be pertinent at this point to give everybody a moment to just review that before continuing.
Taxpayer evidence.
Yeah.
So I have-
Is anybody still reviewing? Has everybody had adequate time to?
Give me just another minute or so.
Not a problem.
There's a lot there.
Okay.
Okay.
All right.
So hopefully that clears up some of those questions, but I think what you're trying to get at is that there was an intent for the Dr. and Mrs. Bruce to move to this other property to optimize their taxes and then return to the other property. what they're saying in this affidavit is that there was clearly a different intent in their mind as part of their end of life planning and trying to reduce their responsibilities. And then life happens. We all know that last year was one of the strangest years, at least in my lifetime, in a lot of regards. Not only COVID, having the business complications of having to care for a community, especially ravaged by COVID, but also the death of a father and a brother of that married couple. There was a lot of things going on. So unless you have reason to dispute something in there, I'd be happy to discuss that. Do you have any reason to believe that there was anything contained in that affidavit that is not true?
Yeah, so in answer to that question, I believe that that the circumstances driven around the homestead exemptions being so close together, the fact that the ownership of the original property never changed, and the fact that they're trying to pull that back shows the intent, or at least the fact that there was a red flag in my mind. The fact that I don't have the Bruces today, and this ARB does not have the opportunity to hear my cross-examination of anything that they have to say. I understand that this is an affidavit as they appear to their facts, but I still don't get to ask them questions about.
Sure, but I mean, we also could have asked them questions before canceling this homestead exemption. Could we not have?
Again, if you're saying to me that they never vacated the property at 3036, is that what you're indicating to me?
No, that's not what I'm indicating to you. I believe that's what you've expressed you were unclear about. At least earlier you said you weren't sure if they vacated the other property, and that's why you canceled this, because you weren't sure about something.
Yeah, I said that I
figure they're,
I said that I wasn't an investigator of vehicles. You gave testimony actually about what those vehicles were, but I don't get to ask questions of the Bruces of when they moved out, what their intent was, because this looks like to me, and again, this looks like to me that they're trying to get this property to have ownership. They actually never even transferred ownership. They've had this property, and they're trying to get a lower tax obligation for the rest of their practical existence associated with this.
so are you saying that their homestead is being denied because the tax bill is going to be more convenient for them and less convenient for the district?
No,
I'm looking for an articulable reason why they weren't entitled to a homestead exemption for that property other than an inconvenient tax rate.
Mr. Falk,
It's his turn.
you get, no, it's not his turn. No, it's not his turn. I get to answer questions, and you don't get to put other words in my mouth, Mr. Falk.
Please, I would like to understand your argument than just.
Mr. Falk, it is very unique, and it has red flags all over it when I see situations that come up like this. This is not normal, and therefore I am bringing it to the attention of the board. I'm bringing it's as a matter of public record, and if it's your assertion, it's congruent with the affidavit that your client has provided that that was not their intent, and they're not doing that, and it was their residential homestead to be in the mobile home, then that's your case to make. That's why we're here today.
Well, you've denied it. I just want to understand the grounds upon which you retroactively canceled their previously granted homestead exemption, so that when I go to make my case, I know what target I'm shooting at. But thus far, I'm dealing with a more general suspicion here, and I don't have a lot of evidence on the record to support your position, to support that cancellation, to be critical of. There was a conversation with a neighbor whose name I don't know.
Right. I didn't submit that as evidence. It's just my testimony of a conversation that I had, trying to understand the facts of the case, trying to understand when the Bruces moved in, when they moved out, when did they establish as their residence, when did they establish as their residence. I have a lot of questions. So
did you ask them?
I asked property owners. We have a
call Dr. Bruce or
statement by your clients.
And what did the property owners state, Mr. Soto?
Yeah, well, it's there. We've all read it.
Okay. So do you see the problem that I'm having here? I'm trying to understand if there's a basis in law other than your suspicion as to why it was that they weren't entitled to a homestead exemption on 914 Latrone. They submitted paperwork, which if they were moving to that property, and it would then be proper for them to, if they have no intent to return to FM 3036, then, and they're considering this their new homestead, they're moving forward with that. I'm applying, I'm telling the county's appraisal district that that is no longer my homestead. My life has changed, my circumstances have changed. This is now my homestead. And then due to whatever reasons, they had to return back to the other residence. And then the next year you say it's strange. Well, no, now they're back at this other residence and they're telling you, properly updating you, stating, this is now my new primary residence. This is how I'm holding myself out. And we've granted that. There's still a whole bunch to be determined in the middle. Is there any other articulable reason? Is there a minimum amount of time that they didn't live in this other house? Do you know how long they lived in this other house?
Since,
Like, is there a minimum amount of time that I can look to that somebody has to live in a property to qualify for a homestead exemption?
as Mr. Falk asked the district's legal position, I'm going to address that. The district's legal position is that the house on Latron was not the Bruce's principal residence, as that term is used in section 11.13J of the Texas Property Tax Code. The district looked at the timeline that the Bruce's were in the house on 3036 in 19. They asked for a homestead on the manufactured home in 20. And then in 21, they're back in the large house, the 3,000 square foot house, I believe, asking for the exemption. So based on the timeline, the district position is that the house on the Latron, the manufactured home, was not their principal residence in 2020. That is the district's legal position.
So Mr. Soto, we determined a few things have happened here in a timeline, and the district's position is such as Mr. Evans just described. Is there any other supporting evidence other than this is a theory based on this timeline? Any other reason to believe that this wasn't their principal residence as case law would have it defined?
As far as case law, which case law are you referring to? First, well, let me answer the question, and you can refer to the case law. But as far as the red flag or the suspicion that I had, it has to do with the very quick nature of applying for a homestead that happened late in 20 for a January 1, 21 or January 20 valuation for a 20 location. It was a late application, and then not even within the year's end, there's already a question of moving back. That's, you know, you're asking me if I have anything beyond that suspicion. I'm the purveyor of the applications. That's not normal.
Sure. For the panel's benefit, there's supposed to be evidence introduced to support this assertion. Just, I'm wondering if there's any evidence that's introduced into the record.
That's their burden.
For the board. This is an exemption. So the burden of proof is on the Bruce's to prove by a preponderance of the evidence that they're entitled to the homestead. So the Bruce's have to produce the evidence. The district doesn't have to produce the evidence because the burden is on the Bruce's.
This is not a market value question. This is an exemption application question.
Okay. Let's see.
Let's still wait for that case law.
Let me ask you this, Mr. Soto, are you aware of any minimum amount of time that is required to qualify for a homestead exemption under the Texas Property Code?
Not to my knowledge.
Okay, so it doesn't have to be a year here, is that correct? You'd mentioned 2 years earlier, but I just want to make clear for the panel, and I hope I want to get your clarification that 2 years that you're referring to earlier has nothing to do with a requirement of living in a location for 2 years to qualify for a homestead exemption.
The two-year calculation is done as a result of the benefit of a property owner in which they would receive a calculation within 2 levy years, and they would take the lower of the two.
Sure, that timeline does not play into a minimum amount of time that an individual is required to be in a house or to be in a home to qualify for a residential homestead exemption. Is that correct? Can you hear me, Mr. Soto?
I said the
Yeah,
question has been asked and answered. Like you asked the question the first time and I answered it.
Okay, and I just want to make sure, are there any other prerequisites for qualification for a homestead exemption that the Bruces did not meet?
Again, it's my belief that that was not their principal residence.
Okay, do you have anything else to add to support that belief?
Do you have anything else to support your answer?
I'm gonna get to that shortly. All right, I think that is all that I've got for Mr. Soto. All right. Let's see, jumping over.
Something to present on the president's behalf. We can do it at the end of the hearing in rebuttal, if that's the board's pleasure, or I prefer to wait until we're done, if that's okay with the board.
That's fine.
Mr. Paul could mention case law, and I have some case law that supports the district's position.
Sure. If council would like to get that out on the table now, I'd be happy to defer for a moment, unless you'd like to reserve till after I'm done.
That's fine with me. I will go ahead and refer the board to the case of Harris County Appraisal District versus Wilkinson. I believe the board has that case in the packet and forwarded it to Mr. Falk back in September, I believe. I'll give the board a rundown. I've got some more relevant text than others highlighted. And I'll get to that in a minute. The Wilkinsons lived in a house, and they moved to a manufactured home while they were waiting for their other home to be finished. So they had everything. They had done everything they thought they needed to do. They had their driver's license transferred to their manufactured home address. I believe the case said they had their voter registration transferred. They had parties. They had a New Year's Eve party at the manufactured home. And then they applied for a homestead exemption on January 1st. The district denied the exemption. And it went to the appraisal review board, and it went to the district court in Harris County. The Wilkinsons asserted that the manufactured home that they lived in was their homestead. They were entitled to a homestead for the manufactured home. And then they later moved to the larger house, applied for that homestead exemption. We're talking about facts that are pretty similar to the Bruce's facts. The trial court actually granted the exemption to the Wilkinsons. The appraisal district took it up to the First Court of Appeals in Houston, appealed the district court decision. The Court of Appeals in Houston said, looking at the facts, that the manufactured home could not have been the Wilkinsons' primary residence. Because if you look at the timeline, the Wilkinsons, they lived in a house, they moved to a manufactured home. When the third house was finished, they moved into the third house. So the Court of Appeals says the manufactured home for which they sought the exemption was temporary. It was not their principal residence, because they went from one place to the next to the next. One thing I want to point out in this opinion is the Court of Appeals reiterates, and this is on page 3 of the right-hand corner, that exemptions from taxation are not favored by the law and will not be favorably construed. And I wanted to just mention that in connection with the fact that the burden of proof is on the property owner for reading glasses. And so I'm asking the ARB to look at this exemption strictly. Our position is, looking at the Wilkinson case, is that the Wilkinson facts were even better for the Wilkinsons than I think the Bruce facts are for the Bruces. Because the Bruces owned the house on the Farm to Market Road. It was nearly 3,000 square feet. They apparently moved out of that house into the house on Latron, the manufactured home. And then next thing you know, they're in the large house again after they had obtained their homestead exemption on the Latron house. They're back in the large house. So our position is, based on the case law that I presented to the board of directors, that the Bruces can live wherever they want. But in order for a homestead exemption to accrue to their benefit, the property has to be their primary residence. And that's the term that's used in the Texas Tax Code, section 11.13, subsection J. The property has to be a person's primary residence. I'm sorry, principal residence, in order for the property owner to obtain a homestead exemption. Our position simply is this: look at the facts on the ground. They were here, then they were there, then they were there. 3 years in a row, 19, 20, and 21. If you look at the facts, regardless of what the tax code says about property tax freezes, and you get to transport a zero freeze to another place, I believe the answer is yes, if they did it according to Hoyle. They did it according to the rules, if it was their principal residence. Our position, like I said, is that it is not their principal residence because of the sequence of events. But I would ask the ARB to look skeptically at the exemption, to look at their motivations, notwithstanding what's in the affidavit. This is what they get, I believe, that if they get the exemption. Now, with regard to the affidavit, I wanted to mention this, as Mike pointed out earlier. The Bruces are not here. The Bruces live in Aransas County. I suppose that one or both of the Bruces could have appeared to this appraisal review board, given testimony, and enabled us to cross-examine the Bruces to scrutinize their position for this ARB. The Bruces could have also presented themselves to the ARB so that the members of the ARB could ask them questions, but they're simply not here. So the ARB is being asked to rely on the facts contained in the affidavit. That puts everybody to a disadvantage. That puts the ARB to a disadvantage because this is all you've got to rely on. It puts us at a disadvantage because nobody in this room can scrutinize the district's position. Nobody can test the Bruce's position rather, on this issue. So I'm going to also ask that the ARB look at the affidavit with some skepticism as well. But like I said, look at the timeline. It's up to the ARB, of course, to determine whether the Latron property was their principal residence in 2020. We respectfully submit that it was not.
To further echo that, the transitory or temporary nature of the Latron property is the thing that's under question. And the case law that was provided is the basis for the denial of the homestead exemption.
Gentlemen, is that all?
That's all the district has. We rest at this point.
Okay, thank you. Does the board have anything before I continue?
No, go ahead.
All right. So first, I would just like to mention that one, it's not a requirement that the Bruces be here. Two, there is an unprecedented pandemic occurring, and they are chief among the local medical providers in the community. That is what they're tending to. That's what they've been attending to the last several attempts as well, and that's been a problem trying to get this accomplished. But in no way should the board draw any conclusion from as much as I'm sure the district would enjoy the prospect of. Let's talk about Harris versus the Wilkinsons. Now, opposing counsel had stated that essentially the facts in this case are instructive as to their position. In fact, the facts for the Wilkinsons are more favorable than the facts for the Bruces. A quick analysis of this case, you'll see there's a lot of facts to distinguish here. Essentially what the court's getting at is what was the intent of the party when they moved to the house. Now, in this particular case here, the Wilkinsons, they had purchased another home and they were completing another home. And so when they moved into this mobile home for a period of about a month and a half, 2 months, that was always intended as a stopgap measure on the way to another property. That's what they meant by transient in nature. It was never their intention to stay there, for that to be a long-term property. Again, that fact is not present here. There's no evidence that they were on their way to anything else other than the fact that life happened and they had to revert back to the property on 3036 as they discussed in their affidavit. To look at it any other way would be a terrible logical fallacy, a post hoc, ergo propter hoc, just because something happened later. Therefore, this happened because that was because of this over here. No, it doesn't necessarily. There's no causal connection there. And there's been no establishment of a causal connection by the district either. Just essentially that because this later happened, this must have been what they intended to do without any other supporting evidence. But so that is the reason in particular why in this case, they overturned it, because it was transient in nature. What they were trying to identify is what was the intent on the front end. Not only that, but they were only there till the end of January. The Bruces were in that house until mid-July, I believe, sometime. More than half of that year before they left that house and returned back to their other house for the reasons that they discussed. They were past the point in the year when they would have been required to file for a homestead exemption. If they were holding themselves out as this is our new principal residence, and they requested that transition from the one property to the other, they did that in accordance with how they were conducting their lives and how they wanted to hold themselves out to the appraisal district. They conducted themselves accordingly. When circumstances changed, it's not suspicious that they then transitioned back with their exemption application. That's what they were supposed to do, because now their primary or principal residence had gone back to FM 3036. It would have been improper for them not to update the appraisal district. There was no argument that it was improperly filed on the first time. It was granted. On the look back, he said he wasn't sure whether they vacated that property or not. We're canceling homestead exemptions, property rights under the state's property code on the basis of we're not sure if they had vacated a previous property without an attempt to call the property owner and ask them a question. That's a pretty dubious prospect, and I don't think one that this panel should favor. But this case, if we take a close look at it, these facts, one, are not better than Bruce's facts, but two, is exactly instructive as to why this case does not apply or support this position, because it's totally different. They stayed 6.5 times longer into that calendar year for which the homestead exemption was requested than the Wilkinsons did in the facts of this case that was cited. And it was by definition a transient stay because it was on the way to completion of another house. It was always intended to be a short period of time. Now, subjective intent is hard to ascertain, and I understand this review board's the difficult prospect of having to try to do that, because I know that's what the appraisal district's asking you to do. But absent any additional evidence on the record, that's a really large leap to make.
Mr. Falk,
Yes.
could we have about a 2.5 minute recess?
Surely.
Yeah, I could go too.
Yeah. You'll have to excuse.
Saw you was
Boy coming home for Thanksgiving.
Yeah, he's coming home for Thanksgiving. Yep. Yeah, I'm looking forward to that. How about yours?
Yeah.
That's good. Good. Yeah, just a quick break.
Mr. Falk, it may take more than the 2.5 minutes. I'm just running the computer here. We have a single
Just fine. I'm going to take a quick break myself, if that's all right.
We have a single bathroom here for several people to go, so it may take more than the 2.5 minutes. I just want to let you know.
That's just fine. I'm going to be off camera for a moment myself doing this thing.
The weird thing about a transplant is it completely wipes your immune system out.
Exactly, does that come back?
Yes, over time, over a long time.
Can't be accepted like anything.
Right. One of the weird things that they do is they basically kill you on the inside. Well, circulatory system. And immediately when they put that chemo in you, then they turn around and put your stem cells back in that have been cleaned up. That goes directly back. And then over a period of time, those stem cells start reproducing, and then you do blood tests every day for a while. And they start looking at white blood cells, are they coming back? Platelets, what are they going to do? And then they start looking at the other things like hemoglobin and red blood cells. And there's something else, but I don't remember what it's called. The other thing that happens is that you lose any immunities that you've had for your whole life, such as the polio vaccine you got when you were a little kid, the mumps, measles, and all of that stuff that you got when you were over a period of time, because they can't just automatically start shooting you full of stuff. No. You can't, because some of those are live vaccines. So they can't put those things back in you until you have enough of a whatever to be able to handle it. Of course, now with COVID, that's the big thing, because some of the doctor that's over it, he sat there and told her, right? He said, because she's, she had a really tough time with COVID. And just as easily, you could have it worse than you had it. You won't survive it probably if you got it that bad. So, she's basically just like inside the house, and she's pretty standoffish with people. And that's good. That just drives.
She's still on oxygen.
Oh, no, she's not on anything. She takes, basically, well, our diets have had to change a bit. But of course, she takes a gob of medicine every day. And so she's healthy. She feels great.
When did she go back again?
Next month.
No more isolation.
Well, yeah. She'll be isolated for 6 months.
In the hospital?
Oh, no. Oh, no. She doesn't have to go check in.
Like
She doesn't have to go check in at this point. She asked, was it successful? Well, as much as we know at this point, we tell you to go home and enjoy your life. Your life could be a year, your life could be 5 years, your life could be 10 years. We don't have any idea. His comment is, I could walk out of here right now and get run over by a car. I don't know. His comment was that, if we have a patient who only goes 4 or 5 months and then has just falls off their table, that's a fail. We expect.
Your thoughts?
So right now we're at 30. No, he said he was taking a break too.
Okay.
Yeah, he's here.
Oh, is he there? Oh,
He's
okay.
here.
Okay. Oh,
Go back.
Yes, sir.
Okay. Proceed.
Alrighty. Just want to touch on several things from the packet that I submitted. If you look just behind the affidavits in the order on the PDF in its entirety, it should be page number 8. There is stamped received in May of 2020, a transfer request officially made by Robert and Melissa Bruce to transfer that homestead exemption from 3036 to 914 Latrone. This was sent and stamped received. Also, in addition to that, the form just below Form 50-808, part of that process. If you look down just below that on page 10, you've got correspondence to Dr. Bruce from Appraisal District staff stating more or less that everything is in its proper order and it is time for them to formally request the exemption transfer for 2020 from 3036 to the new property, which then, as we just discussed, they had done. And of course, we know it was received and approved by the Appraisal District's office. To further supplement, just so there's no question as to qualifications, if we move just further down, you have a warranty deed from the prior owner, also stamped filed in the county of Aransas, as well as bill of sale. And then if you continue down, you've got energy company bills listed at that address for Melissa Bruce. And that shows the first bill date, the period being for November 21st to December 11th of that previous year, and the final bill for a service period of June 11 through July 13. That was the final bill before they vacated that property and returned to the other house on FM 3036. As well, Wi-Fi. We've already discussed the fact that their addresses, as Mr. Soto already stated, the addresses on their driver's license also reflect 914 as well. And I'm not sure how many indicia this board would like to discuss to consider that that question of how they held themselves out in terms of their principal residence, but they had also changed their voting precinct and corresponded with their new representation in local government. There are any number of manner in which they've evidenced this was their intent in terms of their principal residence. This is what they intended to occupy and how they intended to hold themselves out in accordance with their personal beliefs and in accordance with the application for homestead transfer that they swore to and submitted to the district for consideration, which was eventually granted. What else needs to go in there?
May I ask Mr. Falk a question?
I will make myself available.
With regard to the property at 3036, did the Bruces buy a tract adjacent to it in November of 20?
November of 20. No, I don't believe they bought it. I believe that that was a property adjacent that they had already owned that they, because they're trying to sell the property at FM on 3036, and they're still trying to sell the property on 3036. They wanted to make that property more attractive and put those properties together, if that makes sense. But I do believe, and correct me if I'm wrong, Mr. Soto, I do believe that property was already owned by them.
Okay, so they were just replatting the properties or something?
Says something about that in
That's what the affidavit
the,
says.
Okay. It says we had already decided we are no longer willing to maintain the acreage. So this was in an effort to break them apart?
No, they are trying to sell the entirety of it and to make it more attractive for potential buyers. I do believe, I don't want to contradict their words, as I know they touched on it in here.
Well, of course you don't.
Yeah, it's directly referred to in the second paragraph of the second page, middle of that paragraph. We replatted the property in November to include our gardens to make it more attractive for potential buyers.
And who has the listing to sell the property on Farm to Market Road 3036?
Well, I don't think it's listed anywhere right now. There's a pandemic going on and there's this controversy in question.
And did
There
it
were,
have anything to do with the market value and the market robust nature in Rockport right now? I mean, when there's many sales that are transacting in and about Rockport.
well, sure, but I mean, is it the purview of the appraisal district to, let's see, adjudicate the prudence of real estate prospecting, or?
No, it's just trying to, because we don't have the Bruces here to ask all the questions thereof, we're asking you questions as they relate to the efficacy of the affidavit and where do they stand in the real world? Like, if it's going to be marketed and all this stuff, and, you know, was their intent to do this or their intent to do that? Love to ask those questions. Can't. But here's the thing, the burden is not on the district, the burden's on the person applying for the exemption. That's an important distinction.
Did the member have a question? I saw a hand raised.
Yeah, but I think they reserve, do you reserve all your questions at the end? You can do it however you want to.
We'll take our questions at the end.
Okay.
After you gentlemen have completed.
It's a simple one. Oh, wait.
Mr. Falk, you have any more?
Looks like I have at least touched on to make sure that everything is in the record with regards to ownership of the property, having established residents through their testimony, electric bills, so on and such forth. Let's see, I guess if the board members have any questions prior to my wrapping up my case in chief, we're still gonna have opportunity for closing arguments. Is that correct?
Yes.
Okay. I would like to make myself available to the board for any additional questions.
Okay.
I'll go ahead and ask mine. Who is
Yeah.
Lisa Bruce?
It's his wife, Melissa.
And
Melissa.
Melissa are the same person?
Yeah.
Okay, that was my question.
Yes, sir, that's correct. That was an easy one. Are there any other questions?
We may come up with some questions when we get into our own discussion.
Okay.
But according to the rules, you get to make your closing statement as well as Mike make his closing statement before we go into our discussion.
Okay.
I'll start with the closing statement and then allow Mr. Evans to see if there's anything he'd like to add to that. In closing, what I'd like to say is there's hundreds of applications that are applied for every year. There's numerous, there's all kinds of different kinds of checks. Some have to do just, as a person applying for the exemption, do they have exemptions in another county? If so, are those exemptions in place? Have they asked sometimes if they're over the age of 65, have they asked for an exemption tax sealing certificate that they'd like to request from that other district to then apply to this district? It's all in an effort to try to have a continuity within the state for proper applications of homestead exemptions. And the homestead exemption and the over 65 exemption are tied together. You don't get one without the other. So basically, when a person turns 65, they are then eligible for more exemption. In this case, it's 25 plus a 10, so that summation is 35,000. In summation, as it relates to the Bruce's application, the timeline and the condensed nature in which the applications were then applied for. Again, we're talking about a January of 20 application for which was applied either in April or May of that year. So already 4 months kind of behind the line. We're already in the appeal season. It was granted because their driver's license actually matched the situs at which they were applying for. That's one of the major checks, right? You know, the driver's license, does it match? Yeah. Was it there prior to them applying for it? Meaning, did they have it in place prior to them? It's another test that we look at. That's something that we're checking. Again, it was applied for. Until November runs around, or in the fall, and they're asking for the tax sealing certificate associated with that because we want to move back. This had not even been in place for an entire year. It hadn't even been in place as far as our office was concerned from May, June, July, August, September, October, November. You're talking 6 or 7 months. We had just certified the roll in July. The taxes associated with every property in Aransas County were then not even, the tax bills were going out in October. And then the very next thing I get, not that I'm looking at because at this point, I'm not looking at the Bruces at all, not looking at anybody at this point. At this point in the process, we're just getting through the appeal season, tax, the end of year processes as it relates to the comptroller reports are going out. And this is the very next thing. Hey, Mike, I just got this. What is this about? I get it from one of the staff members. I said, whoa, wait a second. Didn't we just get isn't this, we don't even have a free ceiling to draw from because it hasn't even been a year. Like in the calculation, this is not something that we see. We don't see this. And therefore it raised a red flag in relation to the temporary nature for which the subject property owner had applied. And since the burden of proof lies with the property owner, I then started the process by which, hey, how do we go about denying this? How do we go about revoking this exemption that was in 20? Because I believe that this was temporary in nature, not their primary residence as promulgated with the Texas Property Tax Code. Again, that's my purview based on the intense, condensed application initial process and then starting to go back process. It's just not normal. Anything else?
You're not gonna add anything, Jim?
I think Mike articulated the district's position succinctly, but
Okay, Mr. Fogg? We can't hear you. We can't hear you.
Can you hear me now?
Yes, sir.
Wonderful. I want to thank everybody for the time being here. I know this can have been kicked down the road a few times, so I'm glad we could take care of it. So we've got a problem in how we're trying to analyze these facts. What we've been able to establish in the record here thus far is that the application was sent in, the application was approved, the application was then later denied because of facts and circumstances that subsequently had transpired after approval. Now, it's the district's position, unless I'm misunderstanding it, that the intent of the property tax payers was never that this was going to be their principal residence, but have offered nothing in the way of that other than on the backside. This is what we think the intent was because they ended up moving. But when we're looking at the case in particular that they had referenced, the Harris County versus Wilkinson, it's distinguishable from the facts here in two very, very important ways. One of which being the amount of time those individuals only resided in that premises till late January, if I remember correctly, of the year for which they were claiming the homestead property tax exemption. But most importantly, which is really the crux of, I believe, the argument they're trying to make, that this was never intended to be their primary principal residence because, as Mr. Soto had once said, the transitory nature. Now, the difference between that case and the facts here is, one, again, a drastic difference in the amount of time, but two, they went into that property never expecting there to be long-term. They were literally in there as a stopgap measure on the way to something else, and that was part of their intent going into it. That is the reason for the holding as it was had by the court in that Harris County versus Wilkinson. They intended to go into that property on a short-term basis. There has been no establishment of a parallel there with any facts of the case at hand with the Bruces and Aransas County Appraisal District. I presented the affidavit to Mr. Soto and asked him if he could disagree, could provide evidence to undermine any aspect of that affidavit and what was stated. He wasn't able to do so, but simply he presented a vague position that it is their belief on a backside analysis that because they left and went back, regardless of the reasons that they testified to via affidavit, regardless of those reasons, that it's still his belief that their intent was that for that not to be their principal residence. Now, we demonstrated the fact with, let's say, their affidavit that they moved into the property. They lived there on January 1st and held it out as their primary residence. They paid bills there. They established their driver's license there. They had registered to vote there and interacted with their local politicians. They had made good and valuable improvements on the house. Lord knows the assessment will reflect that to some degree. But here's really where the problem comes in for my clients too. They're given correspondence from appraisal district employees saying that everything's good to go. It's time now to formally request the transfer, which they did, and they complied with everything and got it approved, and then sacrificed their homestead exemption on the house at FM 3036 in accordance with how they were holding themselves out to be principal residents at 914. And then on the backside, they're being told, never mind, we're canceling that. But there's never even a conversation either about is if that's the case, then it never would have changed the nature of the homestead exemption status on the previous property. But there was never a discussion about that. There was never a discussion about reapplying that exemption for the year 2020 either. We discussed the fact that while he had these red flags, essentially, he didn't take the time to try to contact Mr. Bruce and really ask him what was going on. I mean, we're canceling property tax exemptions because we just don't believe somebody without any other articulable proof. We're just canceling homestead exemptions and then trying to shift the burden. At a certain point, there's reliance here too, because taxpayers are relying on the assertions and correspondence of appraisal district employees. These are their property rights, and they're conducting themselves in a manner in accordance with the advice and the responses from appraisal district employees. Should we not be able to rely on those assertions at a certain point? So we denied that, or we retroactively now canceled this homestead exemption. We weren't able, we established they were in the property, we established they owned the property, we established that they weren't given an exemption for any other property in 2020. There's no other evidence that they didn't live there other than he doesn't believe, or he wasn't sure if they vacated the other property. So we've made a prima facie case for why they would have ordinarily qualified for a homestead exemption, and the homestead exemption was initially granted. At a certain point, the burden has to shift back to the appraisal district to provide some evidence into the record as to why this denial is appropriate, other than I wasn't sure if they had vacated the previous property. And this is my belief based on the fact that their tax bill will be lower. Boy, if I don't know anybody who goes into life trying to pay more taxes than they absolutely have to. That should not be a foundation for undermining a property right in the state of Texas. With that, I'll take the rebuttal from the appraisal district.
Let me just say that based on the facts that the ARB has, the ARB is entitled to infer from the facts that the Bruces never intended the property of Tron to be their homestead. Again, you can connect the dots. The first dot is what was going on in 2019. The second dot is the Tron experience. The third dot is they're back at Farm to Market Road 3036. We respectfully submit that the Bruce's facts are very close to the facts in Wilkerson. Wilkinson. In Wilkinson, they too got their driver's license address changed to the manufactured home. I believe there's some statements in there that they got voter registration. You know, that's all well and good. I mean, that's, you're required to change your driver's license to your homestead if you want to get a homestead exemption. That's a given. If the Bruces hadn't done it, then they wouldn't have gotten the exemption from the start. So those are kind of red herrings. I mean, if somebody wants to make a record, that's the thing that they're going to do. But what you have to do is look at what really happened, and Mr. Fall keeps referring to the back end analysis. Well, that's exactly what happened in the Wilkinson case. The Court of Appeals went back and looked at the fact that after the so-called exemption year, they went and moved to this different residence. So there was a big picture analysis of the Wilkinson case, just like we are providing a big picture analysis to help the ARB in this case. But like I said, the ARB can infer based on the facts that there was no homestead entitlement in 2020 to the Latron property. You know, this business about are they entitled to rely on statements by the appraisal district staff? Let me just say this, that the code says that if the chief appraiser, this is in 1143 of the code, if the chief appraiser discovers that an exemption should not have been granted, then the chief appraiser shall investigate and shall remove the exemption if the chief appraiser believes that it should not have been granted. There's no discretion by the chief appraiser. It's mandatory. The code section uses the word shall. And so because it's mandatory, you know, Mike looked at the situation, Mike looked at the big picture and concluded that this was not the Bruce's principal residence. And because it was not their principal residence, the Latron property, he was required to remove the exemption. So, you know, regardless of who said what to whom, when the application was asked for, when the transfer certificate was requested, et cetera, the fact is that Mike discharged his duty as chief appraiser to his mandatory duty to remove the exemption. So our request respectfully to the Appraisal Review Board is that the ARB uphold the district's removal of the Latron homestead exemption for tax year 2020.
Mr. Falk?
Gentlemen, again, thank you for your time. Big picture evidence here. You said it was his opinion, Mr. Soto's opinion, that it was not their principal residence. Well, Mr. Soto also told us that he did not know if they had vacated the other property. I mean, it's a pretty strong assertion when at the same time you don't know where somebody's living to try to stand behind. You said it, the language is very clear, it's compulsory, it's shall language, shall investigate. Mr. Soto also told us that he is not an investigator. When asked whether or not he even called Mr. Bruce to identify answers to any of these questions prior to just canceling a property tax exemption, he stated he had not. So we can talk about duties and what the language compels us to do. Fact is that just wasn't done. He investigated to the degree that it came out to a result he liked. You know, he stopped a little short, I would suggest, because the reality is there wasn't much of an investigation here. There was a timeline that raised a red flag and the conclusion stopped at the red flag, unless there was something that I missed that wasn't offered into evidence. There's no evidence to suggest any intent here other than the property tax bill, given the actions, would be lower. Sometimes that's just the way that it works out. In fact, oftentimes I think people do things, file exemptions with your office that do lower property tax bills. That's the nature of it. And to hold that is somehow an articulable suspicion that's capable of denying a property tax exemption, that's a real tough argument if we're going to lay that across the county writ large. We're going to have a lot more of these to be had. But again, I want to talk about the fact that they've stated what their intent was here, that clearly is differentiable from the facts in the Wilkinson case. Again, That transient stay was because they were able to suggest with evidence in that proceeding that when they moved to that property, their intent was a transient stay. That is not present here. And there's been no offer of evidence to suggest that. Just the fact that the property tax bill would be lower. And again, they were claiming that as their primary residence past the point in time when they had to claim an exemption for the year. So they properly filed it. It was properly approved. And then later on, they said, well, we moved back to this property during the window for which they're supposed to apply for a transfer to properly update the county, doing what they were supposed to do. To hold that doing what you're supposed to do is also grounds for suspicion. That's again pretty problematic from a logical standpoint. I don't know if this board can allow that to be the basis for a challenge to property tax exemptions moving forward. But at this point in time, I think we've beaten this dead horse. If there are any questions from the review board, I would be interested in entertaining those.
I'd like to interject something. I want to object. We object to the mischaracterization of the evidence. There is way more to support the district's determination about the homestead than just the actual tax situation that they're going to pay. Mr. Falk is trying to make it sound like, you know, we're making a big deal about that. We're really not. We brought it up just to point out what it means. But the evidence that the district has is the evidence that we presented to the ARB, and that is that look at the totality of the evidence, and you can determine that the homestead exemption was temporary. I'm sorry, that was inarticulate. That it was not their principal residence at all on the Tron property.
Because of the temporary nature and the condensed manner in which the exemption applications were submitted to the district.
Yeah.
It was the condensed manner that threw off the red flag. You keep saying, Mr. Falk, that there's nothing beyond the taxable implication thereof. It was the first thing that we presented, but everything else has been in and related about the condensed manner in which the applications were submitted by the Bruces. And as far as investigation and lack thereof, or whatever you'd like to say, you know, you can attack my diligence in regard to this. You know, my aversion to speaking to the Bruces directly has nothing to do with my investigation thereof. I spoke to adjacent property owners about the timeline in which the property owners were there.
Do you know the name of those individuals? I don't think it was ever submitted into the record.
The property owners themselves.
Okay.
But with that, you know, with
Gentlemen.
that, I'm really done. You go ahead and make a decision.
Okay. Mr. Falk, you're done?
I think it just comes back at the end of the day. There need not be much further inquiry than he stated very clearly that he didn't know where the Bruces, whether they had vacated the other property or not. I mean, that's a huge factor. That's a huge factor in this determination. If you don't know, you don't know. And to say that on the one hand, and on the other hand, to make a strong assertion, such a strong assertion as to cancel an exemption. That's why we asked that this board go ahead and overturn the cancellation in favor of the property taxpayer for the homestead exemption for the year 2020 at 914 Latrone.
Okay.
Thank you.
Thank you, sir.
I have one question which just fits into my timeline. I know you kind of answered it. When did they turn 65 exactly?
I think I have the answer for you. Hang on.
And while you're looking at that, if I can just summarize my pieces here. This is from their evidence. They bought the property in November 2019. They didn't file for the exemption on the property until May of 2020. And on June of 2020, they vacated because that was the last electric bill. So we're talking about, well, 6 months from when they bought it, but less than a month from when they requested the exemption and when they vacated.
It's all boils down to though is intent. And there's no indication in my mind that they intended to defraud the county of.
I don't see it either. I really don't see it either. They spent a lot of money on this mobile home.
I'm sorry, I'm on the opposite side.
This whole thing just
Whole thing just smells.
No,
I mean,
I-
Question on the delay. See the question on that delay, gentlemen? There was an issue trying to get that mobile home properly certified.
One meeting, please.
This is our time.
It's our time.
The
I'm
The
sorry.
problem I have.
the question that was
Yeah.
posed, so granted, they're both within the same year. One has I'm not gonna tell you the exact date, but one has one in March and one has one in November.
Of 20.
Let's see, hang on. I'm sorry, I redact that. That's not right. November is when one of the property owners turned November
November of what year?
of. Well, it would have had been 2020.
Yeah, because you said 55.
Yeah.
Okay. All right.
You want
The
to finish
Trump-
summation?
That, to me, because of those dates,
I agree, and I think that the district has made its case, and I'm not trying to accuse anybody of doing anything incorrectly, however, it does appear that it was not handled properly, and that the market had to have the taxes lowered enough back on the other property.
Yeah, I don't see that.
The events is laid out in the affidavit. Do not support that.
I don't support, not that I don't support it, there's nobody here to question about it.
Yeah,
As Mike
that's-
pointed out, the proof is
But
not
we
here.
have used affidavits in the past. And we have not suggested that if a person were here, there would be a different outcome. We
Well-
take affidavits that are signed and notarized as being true. And that they show no intent to do
Why
anything.
would you? You're stupid to show intent.
Yes, but this all, well, look at a couple of other things.
I mean,
The law says that the chief appraiser shall investigate. But the chief appraiser in this case did not call the taxpayer and ask him, what the hell is going on? It's very simple.
well,
It's a
again,
simple
part of
thing
the
to do.
burden of proof is on the protester.
The ARB is not in the mind reading business. So all we can look at is the paperwork. Was the paperwork submitted? Yes. Was the paperwork done correctly? Yes. What did it pass?
Look at the timeline.
Hang on,
it
hang
was-
on. Did it pass the muster within this organization? Yes, it did. We have approvals. We have approvals that it did. You can move anywhere you want to.
Up to
It's a
a
free
point.
country.
Yes, but you
No.
can't,
Anywhere you want to. You can move month to month if you want to.
you can't carry your exemption with you.
Yes.
You
Sure you
don't apply
can, sure
for
you
one.
can.
Sure you can. There's no,
Sure you
there
can.
is no dates on homestead. You don't have to have it for
I thought
2
you have
years.
to have January.
January 1, you have to be the occupier of a principal
And
residence.
they were the occupier in November of
That's-
19.
That's what's under question.
November of 19 is what
There's-
is what they're doing.
There's
I'm uneasy with this cancel.
There's been no
Without any-
evidence
without any
presented
discussion.
that would prove that you were not living on that property. That they had no intention of living in that property long term.
Other than the
Well, then why
electric
did they,
bills.
why did
They
they?
built
put
a
exemption on
driveway,
it?
they built a handicap ramp, they built all kind of stuff on that.
No,
Yeah, but
They didn't
that's-
just
that
move
was-
some fishing clothes into a closet and say, we live here.
Most of that was done was apparently because of the elderly parents that they had in the situation.
That were living
they
with
were
it.
in.
Sure,
Exactly.
sure.
So that didn't mean they were gonna stay there forever. That
But-
point was. they
Don't
were
have to stay there forever.
Why would you?
Nobody ever said they had to
An
stay there.
expensive home and a cheap home. Why would you put your homestead exemption on a cheap home?
gonna-
Because they
And then-
intended to
Because they
sell,
didn't live in the other one.
because they intended to
It's
sell
their,
the other one.
that's their statement here.
They intended to sell it. He
It never
he
went on the
replatted
market.
it.
It's not on the,
He
it wasn't on the market.
He replatted it to sell it and didn't get to sell it before other things happen. we
And
tell
then it
us.
didn't stop anybody from selling property. It sold like crazy for last
He
year.
had other things besides the pandemic.
Huh?
He's a physician, so he was dealing with the pandemic. His parents were,
That's a personal situation. We all have personal situations.
Which
It has
can-
nothing to do
Sure.
with anything.
Well, it could have prevented him from selling the property. He intended
The
to
big
sell the
house?
3036 part, the big house. He intended to sell it.
Well,
that's according to their affidavit.
okay, but it was never on the market.
That's their affidavit.
Intended to
Affidavit
sell it.
is, it's as good as them being here. We just can't question.
Oh, don't you think that there's some value to listening to what our attorney for the district has to say as a lawyer in terms of this case?
The case
Isn't
is
he
not the
not
same.
smarter than, not only smarter, but has more of the data under his control than an understanding than perhaps we do?
No, we got two lawyers here. They're making the argument, so it's not just us. But the case doesn't match.
Yeah.
The case doesn't match. They clearly had, what was it, Williams? Was that the name?
Wilkinson.
Wilkinson. They clearly had the intent to use that as temporary quarters. That was not the intent here.
Well, how do you know that?
From the affidavit. I read the affidavit and I believe it. I mean, we've taken affidavits in the past. You cannot fault them for not being here and sending an affidavit. If we have done for years, we have taken affidavits as being true.
I can't think so. Where are you at over there? No, I think you're on it.
I just can't. Good conscience give this
I
decision.
should be thinking they upheld us just because we don't.
In the Wilkinson case, I didn't, maybe it said it in the paperwork, but how long did they have how long were they in the temporary or the?
You can read it. Let me check.
I mean, they said, the court said it was clearly temporary, but
The,
I believe it was late January.
I can't find the case. The Wilkinsons took the position. On the actual case, I could give you some clarity.
The end of January of the same year. So less than 1 month after the January 1 date during which they would have qualified otherwise for a homestead exemption.
so it was just a month.
Less than. That can be found in the left middle of page 2 of the opinion.
The key is, to me, they had the intention of staying there as temporary housing until they got their permanent housing resolved.
But you don't know that either.
Bill, that's what the case law says. So they were temporarily there. They were building a new
They were
house.
building a home,
Building a house.
Yeah, I know.
so they moved into.
So this was temporary quarters.
When,
This was
And
not
that's
temporary.
in the affidavit of that
Of
case.
that case.
This was not temporary quarters we're
This-
dealing with here.
Mike, when was the request to move it back to 3036?
November.
November.
We're talking about what, 6 months versus 2 months? I mean,
Actually, from the month of May to November is really, that's the condensed nature of why it's
Here's
weird.
my problem when I thinking on all that, which I have to agree with. They applied for, they moved in apparently in what, January, as they say, and applied for the exemption in May. Or April or May. Okay, so it was granted. 3 months later, 6 months later, they want to transfer it back to the house that they already lived in, that they already changed from in the first place. So that doesn't make any sense to me.
Well, it does if
And
you,
the time frame doesn't make any sense to me. I mean, it just doesn't seem logical that that would have been a
But that's
normal
not what we
transaction.
do. It's not what we do.
Well, I'm thinking, I'm sorry, that's my thinking based on the evidence. I'm entitled to that.
I'm with
In,
her.
in the court, in this case, Wilkinson also testified it was his home. And the Court of Appeals disregarded that. So if the Court of Appeals can disregard a sworn statement by Wilkinson where he says it was his home, then I think this ARB can decide to rely or disregard statements in the affidavit.
Well, again, remember, there's no evidence in the record contradictory along the lines of Wilson, that there was any other place they intended to be when they moved there, like there was in Wilkinson. It's just not in the record here, evidentiarily. And it's only in the purview of the ARB's decision-making process to consider what's in the record.
You said November of 21 or 2020?
2020,
It's all in the same year.
not even 6
April
months.
and then November. I mean, most of us don't make decisions that quickly on what we're doing and going back to an existing property that we already had to put the tax exemption back on it, which would have lowered the taxes substantially. Is that correct?
The circumstances dictated that. It's
Well,
outlined in the affidavit, the circumstances that were
we're
going
creating all
on.
kinds of
with the family.
circumstances. I don't think the circumstances of that particular issue with the health and the pandemic and the blah, blah, makes that much difference. It just seems to me, you know,
It can
I'm
certainly
sorry, but it
accelerate
seems
your
to me
decision.
that it's not on purpose. That's my decision.
And can somebody explain to me the applicability of states? So if, for example, one of the taxpayers or owners turned 65 and we used November of 2020, does the 65 exemption apply to taxes for 2020 or for the following year?
For 2020,
For the tax year, and it applies to the entire year. So if somebody qualifies in June for the over 65, they're entitled to it for that entire year.
Okay, and then the exemption, the homestead exemption, which is filed in May of 2020, is a, and assuming it was approved originally, initially, that homestead exemption applies to tax year 2020. And if they applied, I believe you said in November of 2020 to move it back to 3036, that takes it back down to, that takes it, the homestead exemption again to tax year 2020.
Yes, it's frozen the year they turn 65. The
It's
taxes are
it's frozen. It can't be applied. Not the Bruces, but a property owner could not do a free sealing certificate in the same year in which they did it. They have to take it to another property in the next year. And again, when the question was, when can I get my free sealing certificate? Because we want to move back, Roman candles for this one.
In the same year, had it been the next year, I think it would have been a different story. But it's just too.
That's the answer to the question.
And they've clearly stated that they moved back to the other house for the reasons they stated in that affidavit. And it's their responsibility to then update the county's appraisal district like they did as to a change of their principal residence. I mean, they're doing what they're supposed to be doing, yet that's the basis for suspicion that can cause problems.
Okay, so I'm confused. Somebody needs to straighten me out. This seems rather moot since they did this two-step in the same year.
That's my.
And what effect has it got? Because it would appear to me, unless I'm not understanding correctly, they turned 65 in November 2020. They applied for an exemption on Latron in May of 2020. which if they had left it on, would have potentially decreased the tax liability or frozen taxes at zero, okay? But then in November, they moved it back to 3036
No, they started inquiring for the free ceiling certificate
in,
in 2020 for the 2021 year.
so had they requested to move the homestead back to 3036?
That's
That's
the
the whole issue.
that was the communication was, that's the reason it was brought to the attention of the district, was that, hey, what do I do? They're asking for a free ceiling
Yeah,
certificate on
so the free
3036.
ceiling certificate was intended, and when they asked for that in November,
That's the red flag.
that what it would have been if this hadn't come up, it would have been at $0.
Yes.
Okay. So have they ever asked to move? Oh, that's what the free ceiling certificate was about, in preparation of moving.
To 2021, yeah, for 2021.
In a Senate,
It all boils down to whether they intended to live there for some period of time. And my view is, from the affidavit, they clearly intended to live there until circumstances were such that they had to go back.
you can also read into the affidavit. And I guess a cynic might say this, that they received the tax exemption on the Latron property in the summer of 2020. And then they say, oh, good. Now I can get the exemption on the large house and carry that tax freeze over for the rest of our lives as long as we live in Texas. You can read between the lines in the affidavit.
You gotta do a lot of reading between the lines to get to
Not
that.
for me, not for me. That's why I denied it.
A lot
not
of
for
reading
me.
between the lines.
But you said you,
No, that's what, I mean, that's why I denied it.
We heard you.
Well, good. Well, you didn't have to say that to him. You could say that to me. Like, I don't have
He
to
was-
read between, I
He
can
was
read.
speaking.
I can, okay, well, I'm the one reading between the lines. And I'm the one indicating that the shortness of documentation to our office that was submitted by the Bruces gives me question and pause, and therefore, that's why we're here today. You get to decide.
Could have asked the question before canceling the homestead exemption.
I'm asking the question under oath with affidavits, and it's all good. They get to decide, Mr. Paul.
I disagree. I think we can read between the lines, and I think we have a little bit in some cases. We never listened to a case like this before ever. And a lot of underlying factors going on here that I'm not gonna bring up some of my thoughts on that, but I think we have the opportunity to look at it and say, okay, some of this makes sense, some of this doesn't make sense. Maybe in the past, we've always taken them all for granted, but they've all been different cases. They've all been in relation to price of a property or whatever. It hasn't dealt with this kind of situation before. It's all very strange. I think the timing is all very peculiar. I just don't think that anything should change according to what Mike is on the district's lawyer. And I feel really strongly about it.
For a motion.
Where are you?
I'm with you guys. I mean, at the end of the day, it's just like a serving on a jury, right? And you take
Exactly.
what evidence
that's a
and
good
you
analogy.
interpret the evidence, ignore what you want or don't.
You can listen to
And-
somebody right
Sure.
there in front of you and say, you swear in under oath and you don't believe a word he's saying. You know, it happens.
Too bad the Bruces weren't here.
Well, it would have been,
Might have been
Helpful,
helpful, but I don't
you
know
know,
that it would have made a difference.
and I mean, having served on regular juries, criminal and civil,
Me
you
too.
just, you always sit in deliberation and say, gee, I wish they'd asked this question, or I wish they'd answered that question and so on. But at this stage, man. Timeframes.
Unless anybody else, anything else to say.
Go ahead.
Okay. So I'm gonna make a motion on case 54798.
Case number 2240,
Okay,
account number 54798.
thank you.
Okay.
So on case ID 2021-2240, account 54798, I make a motion that we deny the homestead exemption for year 2021 or 2020 for the property at 914 Latron. Is that the correct way to state that?
I second that.
If, and I don't mean to intrude, but would it maybe be more accurate to say you would move to uphold the cancellation of the exemption for 2020?
I'm good with wording it that way. So on case ID 2021.
If I may clarify, if they're canceling that homestead exemption, does that null and void a transfer of homestead exemption initially occurring, or then are we saying that they had no primary residence at all in the year 2020?
Good question.
I don't think that's.
Because that's the effect that this rendering would have.
Well, the only thing we're addressing is the removal of the homestead exemption on the subject property, 914 Latron. That's all we're addressing.
That leaves the property taxpayer without remedy in that regard to whether or not they were entitled to another property tax exemption in that, during that fiscal year.
Well, there may be other things that come up as a result of upholding this.
This is the only issue that we've been brought
Okay.
to our attention, so that's the only thing we could go on.
Okay, so on case ID 2021-2240, account 54798, I move that we deny or uphold the denial of the homestead exemption on the property at 914 Latron Street.
I'll second.
Do you want to say denial or cancellation?
Cancellation, sorry, cancellation.
That's second.
All in favor?
Aye.
Opposed?
Aye.
Aye. Let the record show 3-4, 2 opposed. Now, what do we do 5455117? Case number 141.
Well, the evidence and so on was, I didn't look at the first one. 55117 is the one that I was looking at with taxpayer evidence, protest, and district
I
evidence.
believe the taxpayer evidence.
Is the same? Yeah. So that's a good question. What is the
117.
here? Yeah, well,
What is the issue here?
yeah, that's a good question because
It's the same 36.
same, it's not the same. Okay, the first one was the Trump.
Protest form. The protest form for 55117.
Essentially the price. Into the assessment. Something totally different.
Yeah, well, he's got
Send that in.
Q6
Oh,
and
you got it,
Q11.
you got it, right, it's
Yeah.
here. Sorry.
So was the,
No.
okay, so the exemption was
Case number
modified.
141.
And then property
Protest form.
description is incorrect.
hand delivered my request for the transfer of the homestead exemption.
It's the same case.
Well, she said it's the same evidence as the prior case. It's not clear to me.
Thank you. Yeah.
Just how that evidence relates to this property.
Yeah, exactly. Was the exemption removed?
Let's see. Mr. Falk,
Sir,
what is the issue with account number 55117?
well, to begin with, if there was no, if it's the opinion of this board that there was no homestead exemption that they were entitled to on 914 Latrone, then the case would necessarily be that that's the case because the character of the property ID 55117 at 2662 FM 3036 had not changed. And the homestead exemption, that property still qualified for their homestead exemption. So there's one issue right off the bat, which would then play into any assessed value on this property without a homestead exemption applied. Does that make sense?
Since let me try this. If the Latrone homestead exemption was denied or withdrawn, does that mean that the prior homestead exemption on 3662 is still in place?
So,
Or
let me
2662?
just
Right.
Okay, and let me just clarify that what this board has in front of it at the very top is property appraisal notice of protest 2021. So this is a 2021 protest.
Mhm.
And if he's asking if a homestead could be applied for the year of 2021.
It says 2020.
Well, and for 20,
Where
It's dated 2021 at the bottom.
does it say 2020? And I'm not mincing words. It's just not what we have in front of us.
well, sure, but what I'm getting at is this body's just made a determination, or if that's the determination of this body that there was no homestead exemption over on 914 Latrone, then it's necessarily the case that that's because the character of the property 55117, that character as the homestead, as the principal residence never changed. And thus, a homestead exemption should apply for 2020 and then 2021.
Okay, so there's a couple of different things. One, the notice of protest that this board has in front of itself is the only actionable item that you can act on, and that's 2021. So first of all, I do have an application on file for this account for 2021. Is that correct?
Right, well, yes, because they had tried to transfer their homestead, and then you came back and said, I am canceling your homestead for 914 Latrone, but I am granting your homestead exemption for this property for 2021. But the natural question begs, what about the year 2020? If you were saying that this was their principal residence and their homestead, not 914 Latrone, then should there not have been a homestead exemption applied for 2020 on this property?
There's no application on file on the
3036 property for 2020.
If they want to apply
But
for
they
an
have to reapply every year, it wouldn't have changed, is I guess what I'm getting at.
Okay, so if I have an application on file for the year of 2020 for the 3036 property, I have the ability to change the role for a period of 2 years.
Yeah.
Right?
5 years.
5 years. I have the ability to change it. So if they wanted to apply for the 3036 property in its total concept of, hey, we never really moved at 3036 and we're applying for 2020 and 2021, I would receive that application, I would look at it, and I would get with my counsel, and we would
Well,
do something.
I guess I'm curious is what the remedy is going to look like. Is if
Well, that's not what's under.
they're not saying that they didn't move, their position is very clear. The board held that in fact they did not, that was not the, they weren't entitled to homestead exemption on 914. If that's the case, then that's because their primary residence, in their opinion, or principal residence was still the house on 3036. So I guess, would you commit to approving that homestead? I'm curious why it would require a new application though, if that's the continued nature of the property. if that makes sense.
Because the property owner in question filed for another application for another property that was then
Right.
not to be their principal and primary residence. They're welcome to apply. Everybody is welcome to apply for wherever they are intending to be their principal residence. And furthermore, I know that the district is not compelled, the district is not compelled to answer any question about 2020 on 3036. And this board has no authority in 2020 to make any kind of recommendation for 2020. The only thing under question is 2021. And so what I will say is that if the property owners in question, Mr. Falk, would like to submit an application for residence homestead for the 3036 year, for 3036 for the 2020 year, I'm sorry, thank you. Then really, I would like to see that.
We'll give it serious
Well,
consideration.
what I'm getting at is they've filed, and they're standing behind their opinion here. They filed these documents.
We can only.
You can only rule on this.
He can do something for 2020, but it's not before us.
Exactly right.
Okay, so are they supposed to now say that their principal residence in 2020 was that in another application? I mean, do you see the contradiction there?
I'm sorry, say that again, Mr. Falk, I didn't hear you.
It's problematic. My clients have stated clearly that their primary residence was 914, to then refile and say, no, never mind, our primary residence in 2020 was in fact 3036. Should that not already be the case?
That's your decision.
That's
Mr. Falk.
that's your
We
advice to
we
your
cannot-
client.
We cannot tell you how to proceed. That's your call.
Okay. We'll do.
Was
So there is nothing to,
So
we can do.
the prior homestead,
141.
that
Not for
is
20.
going back to whatever it was, 12 or
They
14.
didn't have one because they weren't old enough.
Right,
Yeah,
yeah.
no, they didn't
not
have a homestead.
65, they didn't have a homestead.
Yeah, right.
Homestead, that's all.
They didn't have a homestead, and they had a homestead. Going back to what, 2012 or
Something like that.
14 or whatever it was. So that was always in place.
Yeah,
Here's the
The 65 is the issue, right?
Okay, so here's the total issue. You have no purview in 2020. That's the
There's
end
no-
of,
there's
the
no-
end, you don't have any authority in 2020.
There's no protest for 2020.
Right,
What you have
okay.
in front of you is
Right.
2021.
And
We're willing to listen to the protests submitted associated with 2021. And they have an exemption on file. The only thing is that in relation to the last hearing, and again, you know,
But do you see the problem? We're just now dealing with the new information, though. You couldn't have had a protest on file.
now that you have the information for 2020 on the aforementioned property, now this 2021 property application exemption that was denied, modified, or canceled, because I never accepted this one because I didn't know what was going to happen with this right here. But if in fact the 2021 is their primary location, the only thing that I would say is that I would grant a new exemption. It basically gets reset. And then if at some point in the future, the subject property owner wants to file a 2020 application, they're welcome to do so.
as far as the 2021 protest goes, there's nothing here to do. You're saying you have a request on file and you're gonna act on it
Well,
for
but
2021.
but with modifications. See, you can accept an application or you can accept it with modifications. And the modification that I'm saying is there's no free seal and certificate with the value of 0.
Okay,
Well, we've already taken that away, haven't we?
Well, that was in relation to a denial of another property. This is another application on file for the 3036 property, for which I am willing to grant
but it seems to
straight
become moot.
2021, but
other
not with
action.
the home, not with the over 65 free seal and certificate. That's the modification. That's why it's under protest.
Is there any, does any of this become moot based on the action that was taken on the Latron property?
That's
As
what
to-
I'm getting at.
Hang on, sir, hang on. As to whether or not the exemption on Latron was canceled, modified, or denied. So what we did on the last one, did we,
For year 2020.
for year 2020, on that exemption, did we support canceling it or support denying it?
The ARB voted to
Cancel.
to uphold the cancellation.
Okay,
But as a result, it does not compel neither the property owner nor the district to grant an exemption for which a property was not applied for. So in my hand,
It had already been applied for.
had been in place.
It was in place.
20, it's not in place.
It was, I think it was in place in 2020, because there's a request from 2020 to transfer it from 3036 to Latron, which implies, I assume, that it was in place on the 3036 property. So that's part of the confusion in my head, right?
Yeah, the exemption that I have on file. I need the, Beth, I need the exemption application. See here, give me just a second.
I kind of see where you are. It's,
Yeah.
it's a technicality.
Right.
Yeah.
But again, the only exemption that I have, the only
That's
thing, the only
irrelevant,
protest that you have,
Sort of.
see this right here? This was received in May
Of 2020.
2020, resident homestead exemption transfer certificate.
Is that your text?
Yeah,
So are you saying that it shouldn't have been granted, that transfer? And then thus should have remained on 3036?
well, and that's kind of why I asked the question of whether we canceled it or denied it. Because if we denied it, then that would say that the prior one stays in effect. If we canceled it, then that says that the new one on 9/14 was in effect and we then canceled it, which means you got nothing to fall back on. They got to go back and refile. To me, that's what it feels like.
Which is what Mike was saying.
Yeah,
I agree with that. We did cancel.
Would not live the property taxpayer without a homestead exemption for 2020.
They can file that late homestead in 2020.
and I can, yeah,
But and the problem with that though is they've got to then swear something that's counter to what they've already sworn to. They've sworn that their primary residence was in fact Latron. They can't then come back and swear, never mind, my primary residence was in 3036. That filing two applications like that under sworn situation is problematic, right? So it's either it reverts back, or I can't see functionally how they can do that.
Okay, well, I want to respectfully submit that the ARB is ruled on the 2020 issue. That what's before the ARB now is 2021.
2021 for a different property.
Yeah, for the farm to market road property. So
And, you know, if we have an exemption on file,
There was an exemption in place prior to the transfer that your office granted.
no,
No,
our
there's not.
position is that when the Bruce's applied for the Latron homestead, that cut off the farm to market homestead.
Yeah.
I mean, we'll sort that out later on. I don't think that's
What
germane to the ARB today.
What is the exact protest on the 2021?
exemption was denied, modified, or canceled.
Yeah.
Denied, modified, or canceled, or property description is incorrect.
And it's not been denied,
No,
Or canceled.
modified, or canceled.
It would be modified under the way, I'm gonna get it for you. It would be modified.
Yeah, if they haven't acted on it yet, or can act on it.
no, what he's saying is always that, reading this correctly, that he wants to include in there that zero exemption did not. And let's go back to the 36.
Yeah.
I don't have it, I don't have an exemption,
Sort out later.
Or you don't have one?
I don't have an exemption on file for 2021. The reason I don't is because I don't have an exemption on file for 2021 for the subject property for 3036. But I am willing to, the application for residential homestead that is here, so you can see that this is an older application here. If I have an exemption application for the Bruces on 2021, I would just say that, you know, if they, I would read it and I would look at it. And most probably, you know, I would look at it, and if it's appears to be there, then I would grant that for 2021. The only modification would be any free sealing certificate transfer, because I don't agree with that. So I don't know what's
So what's being protested?
exemption application.
Yeah, I read the thing, but I don't have anything to act on.
I agree. That's what I think. I think there's nothing to act on with respect to the exemption.
No,
Right,
he doesn't have an application.
right. And that would have been true in any case.
Yeah.
Because there was nothing filed.
Right.
Okay, they went as far as requesting the certificate, but I don't believe that the next step took place, which was getting an exemption, because
Previous residence homestead, 50,117, 3036.
Yeah, but that's-
25,000 from 2019. Tax year, last tax year.
this is the homestead. Oh, look at this. Who is that?
May 7th, 2020 is when it was received.
Yeah, okay. This is to go to the electronic.
If you look at the,
But this
I
was
do
in
have a
place.
letter that I
This was
submitted.
in place.
I do have a letter that I submitted to the Bruces. I think it's in district evidence here.
This relative to 2021.
Yes. Let's see. Here. Okay, I have a letter dated May 28, 2021. It's in the middle of the evidence package. I'm gonna read it into the record.
Your evidence back.
Yes.
It's my evidence package,
Okay.
but it's in relation to the question of an application that's gonna be denied, modified, or canceled. Your residence homestead application for 55117 exemption, removal of exemption on PID 54798. Dear Dr. and Mrs. Bruce, your residence homestead application that was filed on our office February 26, 2021 will be granted for the tax year 2021 for the residents located on 2662 FM 3036. However, I have removed the homestead exemption on the property for 914 Litron for the tax year 2020 because I do not believe that the property was your homestead in 2020. You have the right to protest the removal of the exemption for the following deadline requirements contained in the property tax code, chapter 41.
So was it a removal or a cancellation then?
Well, they talked about both, and this is in the evidence that I provided to you. It talked about an approval for one, that it would be approved for one, and denied for the other one. But since these are both under protest, they were both under protest, wasn't gonna grant one without knowing that the other one was gonna be, the cancellation was gonna be upheld. So I'm affirming that in this 21, for the 2021 year, I will apply. You know, this board can actually come to a conclusion that I can apply an application for a residence homestead for the 2021 year. The only modification is there's no tax ceiling certificate freeze transfer associated. It's just a new homestead. And as far as the 2020 year, the subject property owner can apply for the subject property at 3036 for the 2020 year, which would be, in answer to your question, Scott, would be a continuation that they always had it at the 3036.
Why do we even, can't we just go ahead and approve that?
Again, it's been,
You've already said you give it to them, so.
Well, again, but it's not.
And to save everybody a headache here and possibly a trip down to district court, I'd like to solve everything here if we can get that done. If you're gonna do it, I mean, my view is, and perhaps the board and the district have a different opinion, but if that homestead exemption would continue, if you're saying the character of 3036 property never changed as the principal residence, and thus a homestead exemption didn't apply to 914, then it shouldn't require a new application for 2020, is all I'm getting at.
The Bruces repudiated their homestead on the Farm to Market Road property when they applied for the Latron. So there's a break in the homestead.
Are we saying that they had no principal residence then? Or they just,
That's for them to determine.
like,
That's the Bruce's decision. I mean,
well, I'm just trying to deconflict here. There's an inconsistency. Either, we're trying to say a few things are true here at the same time. If 914 wasn't their homestead because 3036 was their principal residence, you know what I mean? There's kind of an issue there. And now they're left without a homestead for 2020, but you're saying to get one, they have to apply for it and state something that's counter to what they've already stated.
with all due respect, and I hate to sound tacky about this, that's the Bruce's problem. That's the Bruce's issue. They can deal with it ever they want. As far as I'm concerned, as far as we're concerned, the ARB had two issues before it. 2020 on 914, which has been resolved and decided. Second issue is before the ARB right now, which is 2021 on the Farm to Market Road. Now, Mike, you said that there was or was not an exemption?
There's not an exemption on file currently in the record for the subject property in question, which is the 2021 year for the 3036 property.
But is there an application on file?
Yeah, there's an application.
Okay, so the district's position is that there's an application on file for 2021
Right.
at 22662 Farm to Market Road 3036. And the district has no objection to the ARB granting an exemption for that property for 2021.
With the only modification, because
With no
the-
tax ceiling freeze.
right, because because the chief has the right to deny, modify, or cancel an exemption, and it can be protested. But I'm affirming under this public record that I will apply it, but not with a tax ceiling free certificate applied to it. I will just put it on, they'll get the homestead, they'll get the over 65, but they won't get the freeze associated with it.
And we all agree to that, correct?
Is that something that ordinarily, otherwise they would be entitled to?
You don't agree with it.
This is not an ordinary
Do the
situation.
last one.
Right, that's,
They're two different cases.
no, but he, what he's saying to you is just factually right, because he disagreed with the last one, then he disagrees with the logic. But he would still grant, but you would still agree to grant the 2021 on the
Without the condition.
Right, I'm worried about 2020 though, too. 2021 is one thing, but there's a missing homestead exemption last year and a large jump in value on that property that would have otherwise been protected had it not been transferred and then removed.
I don't think that's before the ARB.
But that's not before the ARB today.
No,
Okay,
this whole thing stems on the previous one.
Yeah.
And,
But I'm on the record for saying that I will apply the 2021 exemptions for the 3036 property with the modification that there's no tax ceiling free certificate transfer.
Sorry.
So I'll take a stab at a motion.
Okay.
Okay, I move that we support the action by the chief appraiser to grant a homestead exemption on the 2662 FM 3036 property. And this is with respect to account 25117, case ID 2021-141, that we support the chief appraiser granting the homestead exemption with no tax ceiling certificate included for the 2021, starting for the 2021 tax year.
one minor correction. You did have for account 55117. You said 25117.
Okay, yes, it's for account 55117, case number 2021-141.
I'd second that.
In favor?
Aye.
Opposed? Okay. Let the record show 3 in favor, 2 opposed.
Now,
Okay.
that
have we
doesn't move,
finished this page?
we haven't. Okay, because there's still the question of the other thing on the protest form was the property description is incorrect. There's no evidence that was presented that I saw that dealt with the property description being incorrect.
Yeah, I don't know why they actually filed for that. I feel that's more administrative and I can work with the appraisal district outside of this hearing to have that information updated if the district agrees with that position.
We agree that we can work with you as far as any kind of description for the property.
Too easy.
Once again, we are finished with the cases 141, 142, and 2240. We now have case number 140.
Just over there.
We're in.
That's on the top of the page.
I think we're at 25107.
Yeah,
Yeah.
we're gonna take a break.
We're gonna take a break.
Oh,
Now it's
Mr. Falk,
We're
gonna take a 2-minute bio break.
Mr. Falk,
Yes, sir.
bio break time.
Okay.
oh my goodness.
You should have one like that. Quick one or two.
the jacket. He said, nice jacket.
Had bought anything, which is a pretty thing, damage.
Yeah, we talked about my stuff. How's yours?
Good. I went back.
Go into Val's office real quick.
And
It's fine.
price.
Yeah, it's not good back. Yeah, back for a couple months.
Cool.
Nothing is spreading, nothing's growing. It's doing anything.
Better go.
%. It doesn't stink. What's that?
Alrighty, I think the last one, Mr. Falk, is the last one just a market value decision or question?
That is correct.
Damage.
I can handle it. Okay. That's it. Okay. Scott, look what you did. Look what you did.
Don't tell him.
Look, hey, these are Scott's over here, right over here. Look at these.
I could hear the sucking noise all the way outside.
Oh, it was the air conditioner, man.
I didn't have any just now.
Yeah, Bill's still in the restroom. He's
140.
coming back in a second.
Case number 140.
140.
People out there waiting for us.
Yeah.
At 3 o'clock.
3
We're
o'clock.
30 minutes behind. Okay. Let's try to get this one. Let's just be one more for this.
This is it.
This is a market value.
Yeah.
question.
It's a damage question.
Okay.
It's a Harvey damage.
All right.
I think, Mike, you may have the wrong taxpayer evidence in case 140. You've got taxpayer evidence, I think.
Yeah.
I think in case 140, taxpayer evidence there is actually from our.
No, you're fine. You're fine.
I think all of their tax codes is
It's all the same. Okay.
Really?
That's what Val said, the email that he
Okay.
sent. but
Okay.
they're in all
All
of
right.
Okay.
Mr. Falk, we have to, because this one was singled out separately, we have to swear in again. So
Okay.
I, Charles Powers, do solemnly swear that I have not communicated with another person in violation of tax code section 41.66F as related to case number 2021-140.
I, Robert Dayton, do solemnly swear that I have not communicated with another person in violation of tax code section 41.66F in relation to case ID 2021-140.
I, Kathy Hoffman, do solemnly swear that I have not communicated with other individual relationship. Other person in violation of tax code section 41.66F in relation to case 2021 ID case ID 2021.
Voting case 2021-140, Bill Duck, do solemnly swear I have not communicated with another person in violation of tax code 4166F.
I, Scott Wagger, do solemnly swear that I have not communicated with another person in violation of tax code section 41.66F related to case ID 2021-140.
Mr. Falk, you get to choose whether you go first or whether the district goes first.
If the district would like to proceed, that would be fine with me.
Okay, property ID is 25107. We have a house at 47 Curlew. My name is Michael Sutter. Do solemnly swear or affirm the testimony shall present to the prison review board for the Lance County Prison. Correct. Subject property is 47 Curlew. We currently have evaluation in the 2021 year, which is the subject of protest the 2021 year. 632-170. You notice that we have a 55% complete. You can see that on the card information, which is the property card, this was like a foreclosure sale from Citizens Bank. They paid $484 for the subject property. Currently have the property valued at 55% complete, which means it's just a shell of a home. On the next page, you can see the indication of the pictometry imagery. On the page after that, you see the comp sales. Are both sales and equity under protest?
Just sale, market value.
Just market value. So the comp sales that you'll see in front of you are for 25 Bahama. You can see that the subject is the 6ST. Comp number 1 is the 6ST minus, both 6ST minuses. Comp number 2 is a 6ST plus. There's a, you can see the difference in the valuation. The very first one is a really good comp from the standpoint that it is a 2,800 square feet. The subject is 2,815 square feet. The comp number 2 is 2,670 square feet. There's differences in effective years associated with both the comps and the subject. You can see that the rendered values for comp number 1 is 588 and change. Comp number 2 indicates a value of 641 and change. Comp number 3 has a rendered value when compared with the subject of 596 and change. Comp number 4, you have 631 and change. The only thing under protest is market value, so we won't go over equity. So then when you get past equity, you have the sales ratio report. The market activity associated in Rockport, specifically in Key Allegro, was robust to say the very least. You can see that we have 30 pages worth of sales here. There's a total of 102 market value transactions in the sales window that's indicated. We have a weighted mean analysis of 1.0015. The sale for the subject property, did it transact? Yeah, it did, but it was from a bank. And so, it's not really, in my opinion, a market value transaction. Is there a percent completeness that needs to be considered? Yes, I'm interested to hear what that is. 55% is kind of a baseline for a dried-in area. And so that's what we've given it. If the subject property owner has any other evidence that he'd like to present, other than, like he's saying, well, we bought it for $484. Well, yeah, you did. But it was a market transaction associated with a sale. It was purchased from a bank.
Not an open market sale.
It's not typical. And it was not indicative in the year in question. 102 other sales, and it was very robust in Key Lake. That's what we've got as Jim.
What year was it purchased?
It was in 20. Yeah, it was in, it looks like it was
October 13th.
October of 20.
2020.
Yeah.
20.
Yeah, it's a recent sale.
Yeah, okay.
Is this a 25 date?
No, it's, no, this is a regular 41. Yeah, this is the protest form is right there. And it was timely. This is timely. Yeah, this was received in May of.
So what was this, a reschedule?
Yes, remember that these were all put together and this was a reschedule and this is why we're here today.
Yeah. Okay. Thank you.
Okay, is that it?
That's all we got.
Okay, so Mr. Falk, you have 2 minutes then for cross-examination and 5 minutes for your presentation. So I'm going to give you 7 minutes on the timer here.
Okay, I appreciate it. All right, Mr. Soto, you mentioned that this house was purchased at the sale of a bank. Let me ask you this. Do you have any specific reason to believe why this house would have gone for anything less than market value? Or have you offered anything into evidence that would suggest as much?
Yes, 102 different sales of a robust area.
Yeah, but I mean, the market, like, I get the comps, but this particular house, is there any reason that you have to believe that there was some other reason why this sold for less than it ordinarily might have when it sold?
Yeah, I actually started with that it was a purchase from a bank. It's not typical, especially not in the.
How long had that property been for sale by that bank, Mr. Soto? Are you familiar?
Don't know.
A very extended period of time. I'll just offer. This house isn't like those other houses, though. This house had a hole in the roof from Hurricane Harvey. This house had broken windows that were boarded up. This house was largely dilapidated on the interior, and I agree, comps have a very valuable place in trying to determine something that's very subjective, but there's no better evidence of what something's worth than true market test, which is what we got when this property sat around for a while until it was finally purchased. There was an elasticity of that market point, that demand determined with this sale. And I have provided the HUD-1, the settlement statement for that sale 2 months prior to the valuation being done. Unless November and December were really good intrinsically for values of properties to the tune of 25% or so overall increase in value, it's the position of the property taxpayer that the valuation should be much closer. We're going to ask specifically for 484, which is what the sale price was after that property had sat on the market for an extended period of time without the ability to sell it.
That's an old.
My friend says. That actual membership. That actual. Liked her.
You still have time, Mr. Falk?
That is correct. I wasn't sure if you guys needed a break for a moment while evidence is being shared or what the situation was. I want to clarify though if there's any questions from the board.
I do have a question for you. You say that this house is damaged, but we have no pictures of evidence of the extent of the damage. You said there's a hole in the roof, but there are no pictures to indicate what the rest of the property looks like.
Well, okay, that's true. That was subsequent to the sale, and I'll admit that the property value has gone up because those things have been repaired. But if we're looking for a reason why the property was worth what it was worth when it was purchased, that's why the house was purchased for $484,000 and not much closer along the lines of what it was that was presented as comps by the district and with regards to this property. There's a reason why it was such a large delta, and it wasn't because there isn't an abundance of money being flooded into the Aransas County market. Property values were increasing rapidly at the end of that year. There's a reason why that house wasn't going for sale or wasn't being sold when the bank owned it. The bank was trying to get rid of that house for a long time because it was terribly problematic. We all can imagine what Hurricane Harvey damage looks like. I think we all lived through that. I know my house had a hole in the roof in Rockport. Certainly lowered the value.
You still have about 3 minutes if you need it.
Are there any other questions by the board?
Well, I have one question, is purchased at 484. And now it's complete, is that correct?
Effectively, you could say that. I mean, there's still some finishing touches, but it's not quite there.
Oh, what percent there is it?
Oh, heck. Last time I was there, I'd say about 85%. I mean, it depends on what you're talking about. They do have plenty of additional projects, but it depends on what metric you're using. If you're talking about being able to live in it if you needed to, versus are you ready to sell that if it's an investment property or rent it out?
No, I'm talking about it's a livable property now, correct, as of January 1?
As of January 1, 2021?
Yeah.
I don't believe so. No, that was the vast majority of the remodeling to deal with the Hurricane Harvey damage has occurred post January 1, if not all of it.
The district has 55% complete associated with the damage
Oh, okay.
on the subject property.
Oh, okay, so.
Never mind.
Yeah.
The house was still very unlivable January 1.
And 55% is,
That's 55%, so.
yeah, it's dried in.
Yeah.
That's
Yeah, it
all.
wasn't dried in though. I can tell you that it was definitely exposed to the elements.
Yeah, in the cross examine, the one thing I want to know is, when was the roof redone?
Ooh. I would be lying if I gave you an answer. I would have to follow up and check on that.
Sure, not a problem. So, that's the major thing that exposes anything to the elements, is if the roof is not done and he purchased it at 484, even though that's gonna take it less than 55%, but even if you, you can look at the worksheet and see what you would take it down to, but I'm fine. I mean, if it's something less than 55% complete, then, he's saying that he doesn't know.
Can we look at a picture?
Well, yeah,
January
well,
1?
we did present pictometry in our evidence package, and it doesn't look like there's a roof damage.
That's from on or about January 1?
Yeah, yeah. If you want to go, and what's happening right now, Mr. Falk, is that since we provided in our evidence package a pictometry imagery, the board is now gonna look at that imagery kind of closer up and look at the roof line. And they're gonna. Yeah, 221, I'm coming. Yeah. Yeah, January 1 of 2021. So that looks like this looks like what it was on January of 20 when it wasn't complete, but then it looks complete on January 1 of 2021, the roof line.
Okay.
Yeah.
And you can, Mr. Falk, the evidence, huh?
Where about in that packet are you looking?
Well, what I indicated is that what we would look at the roof line for 2021, which is it's in the evidence package. It's kind of a pictometry imagery of the whole. And because I presented that in my evidence package, the property, the ARB can then look at this pictometry imagery to look at that. And they can look specifically just in 2021, if you just want to put 2021.
It's page 3 in the district's evidence.
And this is it looks like a new roof. So
3, 2.
Has the blue box around the house?
Okay.
dark box around the house.
Dark box, yeah.
The roof appears to be complete, like the Bruces probably bought it and then they put it, the first thing they did is put a new roof, which is what you would do.
Mike, you have 4 minutes to.
Oh, all I would say is that we've taken that into consideration for, we only have basically we have a vacant house at 55%. It's just got a roof and 4 walls and windows and it's dried in. That's what 55% represents. And that's all we got.
January.
Okay.
That's what our evidence is tied around. And if you'll notice that on our sales comparison, that all of that is taken into account. And basically that comp sales doesn't actually support the 632, it only supports the 614. So that's all that the district can support. But, the property owner's agent is asserting 484. So you have, the board gets to decide between the 614 and the 484.
I mean, I will simply submit that when they purchased the property and the condition it was in, that gives us the best indicator of what the approximate value was, even if it's had been completed prior to the end of the year, as the district is suggesting has occurred. $10,000, $20,000 in capital improvements make not $100 and some odd thousand jump in value, absent a lot of the other remodeling that needed to subsequently happen.
What's the $10,000, sir?
Say again?
What's the $10,000 or $20,000 that you're referencing?
I'm just estimating, I'm guessing what it might have cost to have
A new
roof, right?
Have you seen prices of new roofs? Yeah, it'd be like 70 or 80. But okay.
Okay, so Mr. Falk, you have then 2 minutes for protester rebuttal if you're finished, Mike.
Yeah, that's it.
Okay.
I'll have a closing, but that's all I got.
Okay. So you got 2 minutes, Mr. Falk. Anything you want for protester rebuttal? Which is kind of what you just did.
Right. Ultimately, I just, and again, I cannot tell you the exact date that the roof was completed. I'd be lying if I said I knew that. But the property at that time, having spent time in it, was still in disrepair. It was not in a livable condition. The best evidence that we have in this case is not going to be a comp. If we're trying to look at a fair market value, we need to look at one, what was just paid for that? And if nothing else, use that as an objective starting point. And if we want to add on capital improvements from there, that's something to consider. But then to comp it, even if you try to make adjustments for these other properties that weren't similarly situated with bad damage from a storm, you're not going to get a good comp out of that. The best way to determine what fair market value is to look at and start from what did it actually fetch at market after it had sat for a very extended period of time without being able to be sold because of the condition it was in. And that's why it's the position of the taxpayer that the value on that property and the value is taken should have been, if nothing else, much closer to the 484 than what was assessed against it. We would ask that the board find that the property value be closer to $484,000 as was paid for it 2 months prior to the valuation being made for that tax year. That's all I've got.
All right. Mike, you got a minute to close?
In closing, what I would say is that the preponderance of the evidence lies within the sales ratio report. There's 102 other sales that say otherwise. And what I could prove is the 614 in the basis of that 102 other sales. Now, having said that, subject property owner saying, hey, you just bought it for 484, you get to decide between the 614 and the 484. There you go. That's all I got.
Okay. Mr. Falk, you got 1 minute for closing. Any final thoughts?
I just asked the board to come to a determination starting from a baseline of 484, and the taxpayer would like to thank you for your time today. I know this has been inconvenient, but glad we could put this behind us. Thank you for your time.
Okay. So it's our time. I agree with that. The new roof. It was completed on January
614. It's a
Yeah.
$600,000 house. It's got a 55% complete.
Complete, yeah.
I mean, it's
Okay.
55% complete is 337.
47 currently.
Okay, so I'm gonna make a
Currently.
motion then on case ID 2021-140, account 25107. When it comes to Q1 incorrect appraised market value, that we lower the 2021 assessed value from $632,170 down to $614,300.
Second.
All in favor?
Aye.
Done. Okay, thank you, Mr. Falk. Been quite a day.
Thank you, Mr. Paul. Appreciate your diligence on behalf of your property owners.
Thanks very much.
Is he gone?
No, not yet. Hi, Val.
Scott, is he gone?
Yeah.
Okay. Okay.
Thank y'all.
Thank you, Jim. Right, so 3 o'clock docket, here we go.
We'd like to move on to the 3 o'clock docket. We have a request for an extension of one of the 3 o'clock hearings today. It is for Harrington. Which account number is that, Scott? Do you have it?
Yes.
What do you need?
A reschedule.
A reschedule?
Yeah, just so you know, on that particular case, the district agrees with the reschedule.
It is case number 2291, property ID 15576.
Thank you. So it says, the letter says, and it was given to us today, we request an extension of the hearing today, 11/1/21 at 3 p.m. Thank you, Mary Kay Harrington by Kristen Barnaby.
The district agrees.
Yes, that's in 15576.
Your reasoning was?
More time to investigate, talk to Jim Evans and
Which one is this?
15576.
Page 12.
Middle of page 12.
It's not page 12, it's page 4.
Sorry.
Oh, my goodness. Yeah, it's 12 properties. A couple months.
Yeah,
You want to reschedule it?
Sure.
Okay.
Comes back later anyway for other things, it looks like, so.
I guess a motion on it and then we'll move on to our first.
I move then for case ID 2021-2291, account number 15576, that we reschedule this hearing to a later date.
All in favor?
Aye.
Done.
Okay, our first case is 2285, last name Schuman.
All right.
Okay, I will bring him in.
Yeah, the one with the.
Okay. What property, what property?
It's got the card in there.
It's the last one.
And just a moment.
32041.
Howdy.
Easy.
Here's Schuman.
Hey, Mike, how you doing?
Okay. Right there, good, yeah. In here.
it's on the very bottom of the 3 o'clock.
I know it. There's no other-
Oh.
You ready?
Yeah, I was gonna help Mr. Schuman get into this.
Forgot how to do this. Apparently.
Let's go back to three.
Oh, there it is, right there.
And what account number are we talking about?
This is 32041.
Right there. And this will be the evidence. I'll let you click it again. That's what it does.
Ready?
Yep.
Okay, we're opening a hearing on case ID 2021-2285, account number 32041. This hearing is being recorded.
Your protest is Q5 other and Q6 exemption was denied, modified, or canceled.
We are the appraisal review board that will be hearing your protest today. We do not work for the appraisal district. We are appointed to perform an independent review of your protest. The 5 of us around the table of the review board. Mike, of course, you know already, is the district representative. At the end of the hearing, you may complete a survey regarding your experience. The survey may be completed using the survey form and emailed to ptad.communications@cpa.texas.gov or online at surveymonkey.com/r/survey-ARB. The survey is voluntary. You also have the right to appeal our decision. Appeal information will be provided to you with our determination. In accordance with tax code section 4145H, all written material that has not been provided must be provided at this time. The ARB members who are considering the protest have not communicated with anyone about the protest and signing an affidavit to that effect. I, Charles Powers, do solemnly swear that I have not communicated with another person in violation of tax code section 4166F.
I, Robert Dayton, do solemnly swear that I have not communicated with another person in violation of tax code section 41.66F.
I, Kathy Hoffman, do solemnly swear that I have not communicated with an individual in relation to tax code section 41.66F.
I, Bill Duck, do solemnly swear that I have not communicated with another person in violation of tax code 4166F.
I, Scott Wagner, do solemnly swear that I have not communicated with another person in violation of tax code section 41.66F.
All testimony from all witnesses must be given under oath.
Right. I do solemnly swear and affirm that testimony I shall present to the appraisal board for the Aransas County Appraisal District is true and correct. My name is James Edward Schuman.
My name is Michael Soto. I do solemnly swear affirm the testimony I shall present to the appraisal board for the Aransas County Appraisal District is true, right?
Mr. Sherman, by your left hand over there is the procedure that will follow throughout the hearing.
Okay.
You have a choice. Do you want to speak first or do you want the district to go first?
Mine's probably pretty cut and dry. I'll go first. I have no problem.
All right,
Okay.
you have 5 minutes.
All right. My problem with the reappraisal of my property is that after the storm, my wife and I lived on that property 2018 and into 2019. And I don't have any problems paying what I owe, but I feel that 2018 and part of 2019, we were residents on that property. Now, I've been told that because we were living in a travel trailer, that did not count. But I think that y'all need to take into consideration that what was going on at that time. That was 4 months after Harvey, 5 months after Harvey. And there were people living in tents in this town, and we were doing the best we could. And I don't think I should be penalized because of that. That's all I have.
All right. Mike, then you've got 2 minutes for Cross and 5 minutes for your presentation.
Yeah, in the cross time, this all came as a result of an application that we received on file. So Mr. Schuman had homestead exemptions on the property in question. This was damaged by Hurricane Harvey and therefore falls in the 11-135 rule. And when the application for the other place, moving in with his wife, I believe, like it's just up the road or maybe even adjacent to the property in question, it indicates to the district, and this has been done in other cases like this, where he's not intending to complete the structure. And therefore, it's one of those that you have to, like when a person sells it, you have to remove the exemptions for the years in question. And it's just one of those things. You have to remove the exemptions for the years in question if they don't complete the construction. And I'm going to go ahead and read the section of the law because that's what we have here. If a qualified residential structure for the owner receives an exemption under 1113 and rendered uninhabitable or unusable by casualty, wind, or water damage, then the owner may continue to receive the exemption for the structure and the land improvement used in the residential occupancy of the structure. While the owner constructs a replacement qualified residential structure on the land, if the owner does not establish a different principal residence for which the owner receives an exemption under 11-135. That's the key. It's like he's going to this other location. He's applying for this other thing, and it kind of sets in motion, oh, he's not completing the one where he left. Okay. This goes on to say on the second page here, to continue to receive the exemption, the owner must begin active construction for the replacement qualified structure and other physical preparation on the site for which the structure is to be located not later than the first anniversary or the fifth anniversary date for the property described in subsection A1. So he met that first standard. He actually kind of cleaned up, and there's a lot of people that are still building. Next August is the fifth anniversary date, so there'll be a lot of these tests that are coming up. The subject property owner continued to receive the homestead exemption, but he didn't finish the structure. And if you'll go on, you'll actually see the very next thing is this right here, which is the comparison of the Harvey, like right after Harvey, you can see the damage, and you can see that this is what it looks like on January 1 of 2021. So they're basically showing you the same thing. To prove that point, the very next page is the property card for 2017. And notice the value on the 2017 card for the improvement. The structure value has a value of $129,410. But then if you go to the very next year, we have, 2021, you have a value of $11,790. So basically there's hardly any value associated with the house itself. The next page that you have is a settlement waiver indicating by Mr. Schuman that he thought that even in the interim, he thought he was just going to destroy this completely. This is in the year of 2019. We had a value of $0 on the structures, okay? The very next page is a screenshot indicating a Harvey 0, which says that it was destroyed. And then on the next page is what you'll see are screenshots of 2017 through 2021. And notice what's highlighted at the top. You'll notice that in 2017, prior to the storm, the structure had a value, the improvement had a value of $129,000. Then it went down to $880 and went to $0. It went up to $12,000 and $11,000 because in the interim, we thought he was gonna knock it down, but it wasn't knocked down. It's not complete is the point. Notice that the value is still 11,790. Now, and in 22, it's still the same. That's what we have right now. It's the 11,590. This is one of those sections of the law. I wish it's good because it allows people to continue to have their homestead to rebuild. But if they don't finish the rebuild or they sell it or they move, then it penalizes them. It's called 1130.15 penalty. And I'm required, I don't have a choice. I'm required to report this to the tax office. I inform the property owner that, hey, because you've indicated that you're moving your homestead, which means you're not occupying this as your principal residence anymore, or trying to reconstruct this in the interim, I have to do this. It's one of those things in the law I wish I didn't have to do, but I'm required to do. And Mr. Schuman, it's just one of those things I have to do. And it was brought on about because Mr. Schuman wanted to apply or move, his primary residence with his wife. I think the adjacent property to the north, is that right?
No, it was in a house that we owned that had been a rental property in
Okay.
Peninsula Oaks.
So, a different house. So he wanted to move his thing and therefore this is not done. Because it's not done, you have to treat it like a sale and therefore it's the 11,135 penalty applies. The exemption removal are on the years in question, which would be 18, 19, 20, and 21. Yeah.
Did they actually move the exemption? Or
I applied this year. Last year, I couldn't get in here. I didn't have a computer to print out the stuff and the office was closed. But yes, I have moved. And when I came in 19, when we moved into our house, they told us we had to be residents as of the first of the year and we hadn't been. But
so he's applied, there's no problem with the application for the residence homestead in the other location, which is at 217 Ivy. So there's no problem like applying a homestead over there. In fact,
2021.
I believe it's in 2021. I didn't check that. I mean, that's not under protest. It's
Okay.
just the exemption denial and removal for the one in question is the only one under question today. But this is what set it off, is this, when we get things like this, it indicates to us that they're no longer going to be here. And if they receive the exemption for which, the Senate or whoever voted this into law, they were doing a good thing, trying to give people the opportunity to rebuild. But if they don't finish, in the timeline, or if they sell, then I have to do this part of the law, which is the 11,135.
Okay. Mr. Schuman, you have 2 minutes for cross-examination, 2 minutes for rebuttal, so I'll give you 4 minutes on the timer.
okay, we haven't torn that house down because we were in litigation with Tweeda. And that's the only reason that house isn't torn completely to the ground by now.
Sure.
And I just felt that, I didn't know I was violating any laws by
You
living
weren't.
out there. I mean,
You were.
I felt that was my homestead.
You weren't, and you didn't violate the law. In fact, you were exercising your right that was given to you and afforded to you by the law. But as soon as you say, hey, I'm going to be over here and this one's not done, it's not reconstructed, then all the interim years, what the law says is I have to remove those exemptions.
Okay, so
That's all that it is.
my question is my tax base going to be just on the land because that house has been off the tax rolls because it was totally destroyed by Harvey?
Yeah, so in answer to that question, I have about $11,000 worth of structure value. And if you think that's wrong, you get to tell us about it. But that's what we've had for the last, and that's why I have this here, is that I've had the interim years, I had in 17, I have structure value of 129,000. In 18, I have $880. In 19, I have $0. In 20, I have $12,000. And in 21, I have $11,000. And the reason for the 12 and the 11 is because in 19, you told us you're going to tear it all down, but it's still there. So it has some resident value. If you think it's less valuable than the 11, that's your argument to make. You can do that. But I mean, not at this hearing, but you could do that like in the future. The only thing under question was the exemption removal.
Right, and I felt that I was living on that property for 2018, all of 2018 and 2.5 months into 2019.
Yeah, and you were exercising the right that was afforded to you. It's only that when you move or you don't, like, even if you completed the home, let's say you live there in a travel trailer and you're building your house back, but then you build it back, and it's totally built back, and then I get this exemption application. What I do immediately is I send somebody out to go look at your place and go, oh man, Mr. Schuman built it all back. Then you get a property group code that says 11-135 done, which means we don't remove the exemptions and you don't get penalized. But because it's not built back by your own testimony, I have to do this. That's all that it is.
What's the 5-year limit?
That's what's in the law that says that they only get to do this construction event 5 years. And I don't have the answer on what happens after the 5 years.
Which would still apply if he wasn't moving it over to Peninsula Oaks.
Yeah.
Has it already been moved to Peninsula Oaks?
Yeah, that's what I'm saying. That's what I can check, but I have a residence exemption application on file. So I assume that it's there. I can check if you'd like before.
That's right.
Scott, can you check 217 Ivy Lane to see if there's a homestead exemption in place?
Yes, there is.
Okay, all right.
And if he were to tear it down, does that have the same?
If he tears it down, it's still zero. I mean, it goes to zero, but I mean, it doesn't affect, I mean, I still have to take the exemptions off.
By taking the exemptions off, what does that do going backwards? Does he owe money?
Yeah, he does. He owes money for the years of 18, 19, 20, and 21. But so would anybody else that just sold it.
Mm-hmm.
And that's happened, like literally now it's happened hundreds of times, the 11-135, or multiples of dozens of times.
So Mike, you've got 2 minutes for rebuttal. If you need.
I don't have anything. I'm applying the law the way I understand it.
Okay, let's go to closing then. So Mr. Schuman, you went first, so you get a minute to close. Any final thoughts you want to tell us?
No.
Okay.
I guess I'm wasting your time and mine, but I just felt that we lived there, and regardless of where we lived, we should have been able to apply a homestead exemption to that property. Since the property, I mean, the house was taken to zero value since it was destroyed. And we were living on that property as our main residence.
The property has been destroyed.
The house was destroyed, but we had a place up front where we had a friend that had a camper that stayed up there. So we moved our travel trailer to that spot and lived and while we were remodeling the house, we had a house in Peninsula Oaks that was a rental property, and it was severely damaged by Harvey. So while we were rebuilding it, we lived out there.
Would you feel the value is $11,000? It's about what the property's worth now.
It's not under.
That's not under
Oh, I'm
protest.
sorry.
It's the homestead.
It's just a homestead.
Laws is what it is.
Yeah.
The law says something.
I don't know what we can do. Can't do anything.
Can't do it.
Is there anything you can do?
You hadn't moved it.
If you hadn't applied for this, you would still have one more year on the clock to actually complete the home. And, you know, Mr. Schuman even testified, hey, we're living there. Like this is our place. Yeah, I mean, that's exactly what the law provides. This is your place. You get to try to rebuild. You know, but if you don't rebuild, then you're really not afforded the exemptions associated with the zero value structure. So that's all. It's really not that much difference. It's just the homestead. It's like $300 or $400 or something.
It's still like you told me back in May, there's still gonna be penalties
There are.
and interest involved, and I don't really think that's fair.
I know. I agree. I mean, I agree in principle with what you just said. I agree. But I don't control that.
Your hands are tied. Yeah. Okay. So I'm gonna make a motion then on account number 32041, case ID 2021-2285, that we maintain the 2021 assessed value at $70,930.
But you have to
So
state
we're
it
Oh,
addressing the exemption.
we're addressing the exemptions, that's right.
for the years in question.
So for the years, that property ID 2021-2285, account number 32041, I move that we remove the exemptions for 2018, 19, and 20,
In 21.
21, as per section of the law 11-135.
Second.
All in favor?
Aye.
I'm sorry.
All right.
I wish we could do something.
No problem.
Here's our next one,
That sucks.
2293. Thank you, Mr. Schmidt. There's a couple coming in. Next, it's a case number 2293. Last name is Ortiz.
Can you get David, please?
Yes. Case 2293.
What's the account?
42594.
It's 4-2 now.
And it's, and Mr. Ortiz is sight impaired.
Okay.
I will go get his name, and then do you want me to get the Ortiz's?
Get Amen and the Ortiz.
All right.
Last one, page 4. This is a late 25 deed.
Yeah.
Okay. Yes.
I'm not on that.
Oh. Look for
Amen. I can-
4259.
Okay. Yeah, I can do it. So
Right
right
there, yeah.
Cool.
Oh.
Thought it was income for some reason.
Oh.
I think at the very end of the table would be good. Uh-huh. And then we'll pull that chair around for you.
I'm sorry.
Oh, no. Right there.
Right.
Good afternoon. We're opening a hearing on case number 2021-2293, account 42594. This hearing is being recorded. We have the appraisal review board that will be hearing your protest today. We do not work for the appraisal district. We are appointed to perform an independent review of your protest. The 5 of us around the table here are the review board. Mike is the representative of the district. At the end of the hearing, you may complete a survey regarding your experience. The survey may be completed using the survey form and emailed to ptad.communications@cpa.texas.gov or online at surveymonkey.com/r/survey-ARB. The survey is voluntary. You also have the right to appeal our decision. Appeal information will be provided to you with our determination. In accordance with Tax Code Section 4145H, all written material that has not been provided must be provided at this time. The ARB members who are considering the protest have not communicated with anyone about the protest and signing an affidavit to that effect. I, Charles Powers, do solemnly swear that I have not communicated with another person in violation of tax code section 4166F.
I, Robert Dayton, do solemnly swear that I have not communicated with another person in violation of tax code section 41.66F.
I, Kathy Hopkins, do solemnly swear that I have not communicated with a person in violation of tax code section 41.66F.
I do solemnly swear that I have not communicated with another person in violation of tax code 4166F.
I, Scott Waggert, do solemnly swear that I have not communicated with another person in violation of tax code section 41.66F.
All testimony from all witnesses must be given under oath.
Ms. Ortiz, if you'll go ahead and read this aloud.
I do solemnly swear or affirm that the testimony I shall present to the Appraisal Review Board for the Aransas County Appraisal District is true and correct.
And if you'll state your name,
Miriam Ortiz.
all right? And Mr. Ortiz is going to say his name and then you'll read the statement for him.
My name is Juan Ortiz. Juan Manuel Ortiz.
And yes, and then you can repeat after me. I do solemnly swear
I do solemnly swear
or affirm
or affirm
that the testimony I shall present
that the testimony I shall give by now
to the Appraisal Review Board
to the Appraisal Review Board
is true and correct.
is true and incorrect. Correct.
Yes.
My name is Michael Soto. I do solemnly swear or affirm the testimony I shall present to the Appraisal Review Board for the Aransas County Appraisal District is true and correct.
Ma'am, you have a chart. It's in the blue folder, right on the table in front of you.
Okay, she's
That,
got to finish signing for Mr. Ortiz.
Oh, okay.
Yeah, we're still trying to get the paperwork. Okay, thank you. And then Mr. Powers is referring to this.
that's the
Chart here.
procedure, that's the procedure we'll use for the hearing. And you get to choose whether you speak first or whether Mike speaks first for the district. Which would you like to do?
I would like to speak first.
Okay,
Okay, this is a question of a 25-25 delta. I'll remind the board that the calculation for the 25-25D cannot be done until you come to the arrival of the market value for the subject property. All right, and looking at the ACAD evidence, what we have is an element that we have for several properties. It's one parcel, but it has several pieces associated with it. So on the very first card, you'll actually see that this is the, this actually has a home site no. So this very first piece is a 2-story that is not part of the homestead group. All right. This is, that's on the very first page of, it's one of 3 pages. On the second page, you'll notice that the same thing, you'll have another piece that has a 2-story. This is like a main area with some storage attached underneath, I believe. And this is a warehouse for this second piece. So the first one, the first card is a rental area. Is the rental area. The second piece is the warehouse. And the third piece actually has the home site, yes. And that is the 5ST for the subject property. This is the home where they live. And all of these 3 things we have as 100% complete. I think that the property owner is bringing information that's different than that, but this is the information that we had in association with the valuation for the 2021 year. You'll want to notice that that the next page you actually see the 3 pieces there. So all three of those pieces are in the one parcel. You have the thing in the front, this other thing, and the thing in the back. I believe the thing in the back is where you live, is that right?
That's correct.
Okay, so that's where the home site yes is marked. That's the far left of the picture.
What's the big building in the front?
The big building in the front is a rental area that's been converted, is that correct?
Yes.
That's correct.
Okay, and then the middle space is like a warehouse kind of thing, or that's what we have it as? Is it like a storage or warehouse, or what is it?
It's a storage, and it's correct.
Okay, good, all right. And that's how we have it listed. For the comp sales, as you can imagine, the sales or comp sales associated with this is very difficult because it's not just a 1-for-1, you have 3-for-1, and this is it's a unique property in that regard. We currently have a valuation of 581,000 change, or 581,230 overall. It's a 5S we're comparing with the main area of the back, basically. The biggest differences that you see with the comps may do with just the summation of all the other things that other places typically don't have, meaning they don't typically have additional warehouses, and they don't have like a living space that they rent out for, like they actually rent that front building out. They're partitioned in such a way. How many people do you have in there?
I have, at the moment, I have 2.
And how many spaces do you have?
No interlock, and there's 4 spaces.
So there's 4 spaces that are rentable, and he currently has 2 in there, is what he's indicated. Again, I don't have really great comps for that because of the uniquity of the property. All of our market data says that we have a valuation of 638 when you look at all the comp sales. The only thing under question is 2525D as it relates to market value, which is they're assessing that it's more than 1/4 off that value. On your comp equity grid, I have a valuation of 630. On the comp sales grid, I have a value of 638. Both of those values support the value of the 581 that we currently have on the subject property. What I have behind there is just a sales ratio report. And that's, if you'll notice that the region that I have is the Sin area. That's basically the region that's in that South Rockport area. It's basically west of Palm Harbor area. That's really what we have, west of Palm Harbor. So as you're going south to Aransas Pass, it's going to be on the right. And these are actual sales of other properties. But again, I'm just telling you, I don't have good comparables because of the fact that it's so different. We don't normally have a house, and then you have a house with a warehouse, which we do have some of those. But then I don't have a house, warehouse, and a rental unit all on the same property. And all of those things you have to account for. And really, when I talked to either, I think it was Mr. Ortiz, he indicated that like some of the rental units weren't done. And I said, okay, well, you can bring that to the attention of the board, and then y'all just kind of make a decision based on what you see. So that's all I have as far as like basically, that's what I've got right now. That's all I've got right now. So.
And it's basically, the rental part is a 4-plex.
That's what I heard was 4-plex.
4-plex.
It currently has 2 people in it, but it's 4 people, 4 different.
It's 4 apartments.
Right, and that's the very first one, the far right on the pictometry.
Okay. You done?
That's it.
Okay. So, Mr. and Mrs. Ortiz, you have, is that right? Ortiz or Martinez?
Ortiz.
Ortiz, okay. Got the name right.
Martinez is the first one.
Okay, so, sorry. Yes,
It's the wrong one.
it's been a long day. You have 2 minutes for cross-examination and then 5 minutes for your presentation. So I'll give you 7 minutes on the timer to either ask my questions or make your presentation.
Can I kind of question now?
Sure, go ahead.
The only question I have about the appraisal is that the comps, like, it's been said, not comparable to anything. I cannot compare to anything. I call realtors and alike and even dealers, and I could not get anyone to focus on that. As far as fair, good value or handyman special, to anybody's guess right now. That place was built by a total destruction of the hurricane. And so that's how it was arrived, that I'm not finished. And when it's not finished, I cannot present it to the market and say, okay, this is what it's valued for. When nothing's finished, I still got foundations, I still got driveways, I still got a lot of drainage to do, and a lot of work that needs to be done and corrected. Not corrected, because it's everything's brand new, but more or less finish up to be livable. And that's the main focus of my plan right now. And as far as what the chief appraiser said, he's totally correct in everything he did. And if I was in his shoes, I'd probably do the same thing, but he did not know that nothing inside the bills were finished. And that's my only defense I have for that.
Tell me a little bit, or tell us a little bit about, you said you got pictures here, and there's a little, maybe there are pictures of several buildings, but kind of give us a quick rundown on what's not complete with these 3 buildings.
Okay, all the buildings need some work. There's one building that I just finished about 3 months ago. And one apartment from the fourplex.
Okay.
It needs to be finished. And there's another part of that fourplex that is still in the sheetrock stage, and that's why you got pictures in there. And they got cabinets in there, but not installed. They got the refrigerator in there, but not installed. You got no light fixtures in there, just sheetrock. And that's the fourth apartment in that place, on the front one. And you also have a crack foundation, not foundation, driveway that needs to be replaced or repaired. And the rundown also is that back porch, the back porch of the building is hurricane damaged. We're not taking it because it's going to take too much money. I really concentrate the main building rather than the little extras that I have in there. I got no sidewalk up back there for the back entrance, for the front back entrance, or the back part of the door. There's no exit. And then the second building, everything is still in a 2x4 stage. I mean, you can imagine there's nothing there. It's a warehouse. I got the sheetrock, the insulation, but not installed. I got a lot of building materials in there but not installed. And also the back house, they still need some blinds, it still needs some sheetrock repair. It still needs some light fixtures needs to put in. And I still need some electric plugs need to be tested out. And that's where I live. Now, the front part, maybe it's just 2 good units that's rentable, livable, and nice. And a third building that still needs some work. Then the not building, like I said, the apartments. And then they all got meters. Yeah, that's correct. Got 4 meters, but I went in stages. And I put 4 meters because I was anticipating some like $1, $2 got married, and they left both houses. And that was after the hurricane. They had to relocate to Dallas and Corpus Christi. So they left my house there, and they left. They'll return back for them. They're gonna stay there. They already told me. They're not coming back yet. That's it. So I just made it to a fourplex because nobody will rent a 4,000 feet house or 3,400 square feet house. It's not rentable. I can't do it. And so I have to break it down to 4 parts. That's why it's done. So in the future, but it's not finished yet. And perhaps when it's finished, like the chief appraiser said, yes, I'll be able to pay the main, whatever the chief appraiser says. He's fair and he's honest, and I can't question that. But I do question whoever took the final one did not ask me or did not see in there or did not stop and got out the car to look at it. So that's the only thing that I have, because honestly, yeah, my wife just said, did not see.
Disabled.
I'm disabled and my wife's disabled too, so, but that's besides the point. But also, he's back, and if we come to that when I finish, I'll be the first one to call the city of Rockport, the county of Rockport, and the chief of police says, I'm done. Come and look at it. Whatever you want to charge me, whatever you think is fair. And that is correct. Whatever he says is fair, it's fair. But the only thing is, the only problem I have is not finishing it.
Can I ask you a specific question about your pictures?
Yes, go ahead, anything.
There's a file that's labeled first half of pictures. What are those pictures of? First half of pictures.
Can my wife see it?
I'm pulling it up right now.
Okay.
It's the building that is sheet rocked, not the one that's in studs.
Okay. It's a fourplex.
That's the fourplex, okay.
Says first half of pictures. Can you tell us if, is that the front house, the one to the right? Is that the one, the first one as you come in?
There's one apartment that we haven't finished.
Okay.
And how many apartments in there are complete?
Right now I have, I just finished one in February. But this one's the third one. But the other one was finished on February of 2020. And that's when I ran it out. And that's it.
So
what-
you have two that are not complete at all.
There two buildings, they're not ready yet. Two buildings. Yes, sir.
But let's also talk about the beginning of the year. Because you said one, it sounded like one was done in February of 2020.
Uh-huh. Yes, sir.
And then another one you said was just completed not too long ago, but it was after the beginning of the year. Is that correct?
That's right.
So you only had one, as of the beginning of 2021, there was only one unit that was rented or completed.
That is correct. That's yes, that's one.
Okay.
So there are three that weren't complete. Are those in these pictures?
Yes,
Yes.
all in all.
Okay. Now, there's two sets of, the pictures kind of break down into two sets. One of them does not have sheetrock. The other one does have sheetrock, but no appliances.
Right.
Are those two different apartments?
There's two different buildings and two different apartments.
Two different buildings?
Yes.
Buildings, as in the storage building or the
Well,
house?
There's a storage building. One is a storage building, don't have nothing.
That's the storage building.
The studs only is just the storage building, right?
Yes, yes.
We just read the outside, but
Okay.
nothing.
Or
So
you're living in
if I
the
can,
house,
if I can ask her a question,
For sure.
on the first set of pictures, is all of that the first building?
Yes, it is.
Okay, and the second set of pictures is all of that is the storage building? Studs,
That's different.
okay, then okay, so what I'd like, well, whenever their time's finished, I'd like to kind of lead us through.
It is, and so now you have 2 minutes for, let's see, they made their presentations. Now you have 2 minutes for cross and 2 minutes for rebuttal.
Okay, so I just want to verify that by and large, the house that you live in is, with the exception of like a little plugs or whatever, is basically complete.
Yes, sir.
Okay, so then that one's not under question. So building number 1 and building number 2 are under question only as they relate to percent completeness.
Right.
So building number 1, which is the rental, he's indicated that he's indicated that one of the spaces was totally complete, right?
Yeah.
And we know that all of the spaces are at least 55% complete because they're all whatever.
Yeah.
So now we're somewhere north of 55% complete by virtue of you only have 45% left divided by 4. So now we're only talking about 11.2% per unit, even in question, all right? So if we take 55% plus the 11.25, that leaves you with 66.25. And then whatever percent completeness you want to come up with for the remaining 3 units at the first of the year. So it's going to be north of 66.25 for the building number 1.
Building one will be,
This is,
about 66%, 62.
well, it's going to be north of 66% because it's dried in is studs everywhere. And it's more than dried in because it has drywall.
Yes,
Yeah.
that's correct.
Yeah, and so on building number 2, we could go to 55% because it's dried in only and there's
Right.
stud everywhere. So
Right.
building 2, this is building 1, building 2
Well, building two,
is 55% because it's
no,
dried in.
that's south, 55%.
Well, just, okay, with respect, sir, there's a long-standing checklist that indicates that 55% complete represents just a dried in state. So, so building number 2, I'll say that's 55%.
I agree.
So then if you apply building number 1, you got to be north of 66.25,
Yeah, and if
some
you-
number.
And you really only add the sheetrock there because as far as I can see from the pictures, there's not much more. It has sheetrock and
Yeah.
and some
So
paint.
if you want to wag
That's like
that,
60.
if you want to wag north of 66.25 and come up with a number, I'm okay with that.
Yeah, I think it's your 66.25 is generous.
Okay.
Okay, and well, the thing is that,
Well,
You-
it's,
you're
you
right.
have one of them that's complete.
okay, well.
And so, hang on, sir, this is, I'm sorry. So you have 55% dried in studs.
Yeah.
Follow my logic.
Yeah.
The remaining 45% is all that's in question. If you divide that by 4, 11.25 of that is totally complete. It has to be north of 66.25. You see what I mean?
Because you're breaking. it.
Right,
Yeah,
exactly. So if you want to wag it to 70 or something like that, I'm
Yeah.
okay.
That's fine.
Okay, so if you're saying that building 1 is at 70% and building 2 is at 55%, all I would say is that I don't disagree with any of that and just see what the number comes out to be.
We don't have a value in each building. do we?
Yeah, sure do.
Yeah.
We can put a percent
That would-
complete.
Would you like me to do that?
I would like you to do that in the main areas.
Okay.
Actually,
I gotta
for building number 1, just do the, what did y'all come up with?
Say 70.
70%.
70%.
Just throw an improvement, like the percent
I
complete.
gotta open something first.
Yeah.
All right, so
Just
improvement number 1.
improvement number 1, 70% complete is what they said.
Okay.
And building number 2 is 55% complete. You throw it on the whole thing.
All right,
Okay, so then now we have a total value of, after you've done those things,
the total value for 21 of 463,420.
463,420, and that's the land and improvements for everything. Is that correct?
Yes, that's correct.
463,420.
Can I have a motion to set the value?
Okay. So I'm going to move then on case ID 2021-2293, account number 42594. I move that we lower the 2021 assessed value from $581,320 down to $463,400.
No.
So you've established the value of 463,420, and then
for,
And then Charlie, you have the test, or Scott, you have the test?
There's a cap, there's a 10% cap, so I'm not sure which number.
No, it's the appraised value, 581, 320.
Okay,
Okay.
thank you.
Yeah, so you do the test against the total appraised value, or total market value.
617, 738. Where is it? What did you have?
581,320.
Doesn't meet the test.
Can you explain?
No, wait a minute. I did
Doesn't sound right.
1.33. I
No.
didn't do
No, no, no.
1.25.
No, it's 1.25.
It's 1.25.
Scott, you take the value that they have, right?
463, the new value,
463,
463,420.
Times 1.25.
579, 275.
And it makes it by $2,000.
And so,
581,320
It does.
was our beginning.
and so if the
Yep.
number had been 582, you would not have been able to change it. But the
Right.
fact that it's 579, you're able to change it.
Pass the test.
So it does pass the
Yeah.
test.
Good.
Okay,
By the hair of my chin.
okay.
Okay,
463, 420, right?
Yes, so.
you can make a motion that we
Okay, so
tested it.
on case ID 2021-2293, account number 42594, the new assessed value of $463,420 does pass the 2525D test. So the new value then will be $463,420.
All in favor?
Aye.
Thank you, folks.
Thank you.
Keep a pray, folks.
Yes, sir.
You're Karen.
Thank you, sir.
Have a nice
I appreciate that.
He had nothing to do with it. It's all us.
Absolutely nothing to do with it. You can look at the notes on my pad where the signatures numbered.
Thank you.
We
Appreciate it.
try to get ready for the board.
Y'all be safe. Thank you. Okay.
Straight, yeah, thank you.
Okay, be careful. There's a little yellow stuff. Thank you. Yep.
It's like 3 more.
3 more today? I think
I
Val will,
There you go.
Harrington is
No,
9.
Barrington.
So we have Martinez.
Miles. That wasn't.
No, that was Ortiz.
We only have one left.
One left, is it?
Yeah, she may have rescheduled the others because it's a reschedule.
Okay.
Yeah.
I just ran, I can rerun a search and do it by what's still of the hearing scheduled. And there's I'm only showing
Yes.
one. There's one left, right?
No, Aaron settled,
Oh, so there's none left.
not sure. We have an
Okay, I just said
affidavit,
One left.
sorry, not proper. But yeah, there is an affidavit that we need to do, but there's also letters. So we're thinking about doing the letters before the affidavit, just because one of them involves audio. I wasn't sure if you were able to pull that up. He said he sent it somewhere now.
So I only have 19%.
I
I only have 19% on this thing, so you're gonna have to choose one of the other.
Oh, I have a battery pack for you.
Oh.
You want to take over?
Can you put you?
Teaching. Well, I tried. Huh?
Everybody else is gone?
Oh, I was out last time you were out.
No, she just said that
They don't-
had an affidavit.
they don't let me
Remember,
out of
you
here.
plug in 2 of them. if
Yeah,
you
but I
need
don't,
to.
yeah, but I don't have a
I'll
cable,
bring
so
Anybody still here?
In-person ones? No.
So the.
it's getting really close to happy.
A
hour, so
letter? Yeah.
And
if you didn't want to listen to
Pick
the
one of the
audio,
other.
rather than having to go to the.
You're Bohemian, right? You check, right? Come on.
Just click on that.
Let's see.
It's a battery if you need it for your thing. I'm gonna bring you a cord.
Space bar. Will be your quasi.
Oh, I'm only at 19%. I
And
got
I'll give
ripped.
you a little insight to audio editing. This is true that comes about.
So,
software
Robert's
and what
not
to
doing
use.
this.
This
is play pause.
Charlie's out.
This is back 10 seconds and forward 10 seconds.
You're out.
J and L. are back 10
Robert's-
seconds,
Robert's
forward 10 seconds. So you can do
Okay,
this. Kind of interesting, but this link takes you to the timestamp
Right,
at the
yeah,
beginning of the
yeah.
video.
Yeah, and I'm
Okay,
kind of
so
done because I was
It
just
starts
checking
at
over Cindy's.
15:30. And if they want to listen to it, that's where it is. So 15:30 is where it's at. And, you know,
Yeah, this was
if
sort
you
of
want to
like-
write
Right,
that in or something, and you're just like, okay, we don't need to. write the whole thing, You can just skip through it. And like that's a little easier than messing with this thing. You know, it's- So J.
Scott, do you need a charger?
In 10 seconds.
I don't know.
Okay.
36%, I think I'll.
Okay, and
You'll make
space or.
I'm the only one that
I was-
keeps playing with your stuff.
That's what I said. You start screwing around.
And
Then I can just go back in there.
So are there more people?
I didn't actually.
No, there's no more in person.
Okay.
Determination or something. They said the property ID, I don't know what.
Yeah, so what we have is we have one affidavit. It's like a regular thing, but it's just gonna be read in and you just make a ruling. And the rest are to grant future hearings if you want to. There's letters, well, not if you want to. You'll hear whether to grant future hearings. There's there's letters to be read, and then there's chief appraiser motions. I know. Mel started early too.
kind of drug that one thing out.
You droned it out.
You kind of drug that one thing out. Like, come on.
Well, the problem was having a damn lawyer.
Oh.
I needed
It
my
was just a
lawyer.
lawyer. Yeah, well. Your lawyer wouldn't do that.
I'm sorry. Well, since I've taken over, yeah. Yeah, he's the lawyer for the district for a while.
Okay, we got an affidavit.
Yeah, Val. They want the affidavit first.
Okay.
It's case number 735. 50592 property ID.
Case number 735. Account 50592. Last name is Sears Wasilewski.
What's it under?
It's on page 2.
No, I'm talking about.
505.
3 p.m. docket.
Oh, it's under 3 p.m.
Yes,
Okay.
yeah.
50592.
Okay, you ready?
Yep.
Opening a hearing on case 2021-735, account 50592. This hearing is being recorded. What's the,
Under protest is Q1 incorrect appraised market value.
okay, we are the appraisal review board that will be hearing the protest today. We do not work for the appraisal district. We are appointed to perform an independent review of the protest. Protester has the right to appeal our decision. Appeal information will be provided to the protester with our determination. In accordance with tax code section 4145H. All written material is assumed to have been provided with the affidavit. The ARB members who are considering the protest have not communicated with anyone about the protest and are signing affidavits to that effect. I, Charles Bauer, do solemnly swear that I have not communicated with another person in violation of tax code section 41.66F.
I, Robert Dayton, do solemnly swear that I have not communicated with another person in violation of tax code section 41.66F.
I, Kathy Hoffman, do solemnly swear that I have not communicated with a person in violation of tax code section 41.66F.
I, Bill Duck, do solemnly swear I have not communicated with another person in violation of tax code 4166F.
I, Scott Wagner, do solemnly swear that I have not communicated with another person in violation of tax code section 41.66F.
All testimony from all witnesses must be given under oath.
My name is Michael Sutter. I do solemnly swear affirm the testimony shall present to the appraisal review board for the Aransas County Appraisal District is true and correct.
Mr. Representative will now read the affidavit into the record.
Things of the protester, let's see, Mary Ann Wolaski Sears and Donald Sears It is 1516 South Magnolia Street, Rockport, Texas, property ID 50592. Incorrect appraised market values unequal compared with other properties. See attached 3 pages.
Just
I do
just
not
for your
int-
information, Mike, on the original protest form, it was just Q1.
Thank you very much for pointing that out. I do not intend to appear at the hearing either in person or by telephone conference call. This affidavit and its evidence may be an argument submitted with it may be used for the hearing if I do not appear in hearing at the hearing.
Just for clarity, is this another reschedule? So, or is it 25?
This is a 41, so it's a full regular one.
Regular one.
Uh-huh. And as it says right here, the appraisal review board. There was a mistake not notifying us of our requested conference call and protest, and thus we are protesting the appraised value for $96,000 for 1516 South Magnolia. Via submitting this notarized affidavit, we're able to attend this protest meeting. Since we will be out of the country. Our protest centers on 2 issues. First, the character of the lot itself, and the lot requires extensive improvements before a building can begin. Second, the appraised value is too high, and the increase of 31,000 in the appraised value in 1 year is greater than other similar properties. Regarding the lot's characteristics on our lot, it is unlike other lots in the area and unfortunately requires additional monies to build. On the left side of our lot, there is an adjacent lot, but rather than an unpaved driveway for the home of the Water Street, the driveway goes through the entire length of our lot and is used as a parking space, storage space for RV trailer and cars for the Water Street owner. This driveway presents safety concerns for kids playing on our property, and additionally, at a level that detracts from the appearance of the property. We thank you for we think that the safety issue resulted in a favorable decision when we protested in 2020, appraised value. Another problem is that our builder says that the lot must be built up and raised prior to the starting of the building. The land on the lot is lower than the street level. And lastly, there's a flooding problem at the end of Magnolia Street. The builder indicates that the entire lot will have to be raised even more than to avoid flooding problems when we are raining. We were unaware of the flooding problems at the end of Magnolia Street and only learned of it a few months ago by talking with neighbors who indicated that the recent heavy rains led to considerable flooding on the street and their properties. Regarding the appraised value units increase from 2020, the property ID 49233 across the street from us had a land value of 72,000. And it also has the advantage of an effective front of 60 feet. The land market value was from 54 from 2018 to 2020, and 1526 South Magnolia, which is next door to our lot, is a premium lot because it has an effective front of 62.5 feet. The effective depth is equal to ours. The size of the effective front is significant because it allows a wider home and doesn't have the limitations imposed by the 50-foot front and the required spacing between the properties. It is a total square footage. Its total square footage is 10,000 square feet with 0.229 acres for a value that is 100,000 in 2021. That comes out to $10 a square foot. Whereas our smaller lot, 8,000 square feet, 0.18 acres is $12 a square foot. Its land market value was 90,000 from 2012 to 2020. Property IDs 66085, which is 1436 South Magnolia, and 55419, 1504 South Magnolia, are also premium lots because they are both corner lots with good views. They're both appraised at 90,000 each. These lots were previously appraised 6075 from 2010 to 2020. In summary, we believe that the appraised value for the 96,000 is too high. Given the many difficulties feeding or something to the addressed prior to the building, other lots needing to be, thank you very much. Other lots don't need to contend with the safety problems inherent in having a driveway, parking area, alley next to their home. Additionally, the noise and the appearance of the driveway are not attractive feature for this land. To us, the lots don't have these problems and more have features and are less expensive by comparison. Besides these unfavorable characteristics, our lot has been proven unique since it is appraised value has increased by 31,000 in 1 year. We found no other properties in the area having such a large increase. Thank you for your time and consideration. Woloski Sears. There you go. That is the property owner's affidavit of evidence. Moving to our evidence. Let's see. ACAD evidence, we do have a valuation of 65,000. Last year, 96,000 this year. I think the 65 was an ARB decision, but I don't know. We currently have a valuation of $12 a square foot, just like she indicated, with 8,000 square feet, produces $96,000. You can see the subject property where it is on the next page. And you can see that there's, at the corner, there's a house, then there's a lot, then there's a house, then there's that little skinny driveway that she's indicating, then there's her lot, then there's another lot that is contiguous with the house to the right, and then there's another house, and then another house, and then another house. So that's where it lies on pictometry, 1 block off the water on South Rock.
Is that paved, that part of Magnolia? Is that?
Yeah.
Yeah, okay.
Which lots was she talking about that were appraised at 90,000?
I don't know. We'd have to read it again and find out where they are.
52,830 is 90,000.
Which one?
Next door, 52,830,
Next door to her?
Yeah.
It's 90,000.
90,000.
All right, moving on to the sales comparison. This is between First and Second Street on Magnolia. The very first sale is on Third Street. That sold for 111. Sold for 115,000. It's bigger than the subject property, and you can see that it produces a price per square foot that's congruent with 772. You can see 1320 South Magnolia is also another land sale that sold for 100,000. Produces an 884 per square foot valuation. Again, bigger than the subject. Both of those are bigger than the subject. The first one was 14,000 and change, and the second is 11 and change. Column number 3 is it's similar to the subject from the standpoint that it's a little bit smaller. You know, it's a similar size as the subject. It's also on Magnolia. That one sold for $85,000. And it produces a value of $12.10 a square foot. The other one on Austin Street, again, Austin Street, this one's a much smaller property. That one sold for $90,000 and it produces a value of $17.54 a square foot. And then comp number 5 is 5,000 square feet. It's smaller than the subject, $15.30 a square foot. So there's a definite economy of scale when you're looking at all those things. The median value is $12.30, which supports the value of the $12 a foot that we currently have the subject property on. Equity is not under question, is that correct?
Correct.
And the sales ratio board is there. Yeah. That's our evidence.
So is the entire block on the same land table, or
Should be.
Okay,
We can look at the one next door to the right and left, or
Yeah.
whatever you want to look at.
I think I would like to look at.
I would imagine that the one to the left, which is 5289829, that little skinny thing, I imagine probably has something in it that's not quite the same.
Okay.
But pick one and I'll look at it.
52,830.
52830. Got it. It tells the value 52830.
Yes.
Smaller.
Barely. But yes, it is.
It's $90,000, it's 50 by 150.
Can you tell me the dollars per square?
$12 per square foot.
Okay.
About,
This is 12.
how about 65918?
This is $12 square foot.
It is.
Yeah.
Okay.
Say it again.
65918, which is the lot 2 doors down, because it looks like the lot to the right is a double lot that goes through the,
Yeah.
so there'd be some economy of scale there going on probably.
This one is 100,000, it's $10 a square foot. It is,
How big is it?
It's bigger.
it's bigger.
How many square feet is that?
It is 10,000 square feet.
10,000 square feet as opposed to 8,000. And I think they indicated that in their letter.
Okay.
So there's a break between the 8,000 and the.
Show us the table.
Sure.
What about the fact that I'm seeing on here that driveway or whatever it is where they're parking boats and blah, blah, it's not becoming some kind of
I think so.
a deterrent to their property?
I mean, it's got a driveway next to it, yeah.
Not their driveway.
No, it's not there, it's not on their property.
No, it belongs to
8,000.
52,820.
9,000 square feet.
Is the break point,
And then 15,000 square feet is the next break point, and then 35,000 feet.
And anything below 9,000 is $12.
$12.
$12.
Yeah.
Yes.
Okay.
Well, except for 5,500 unless it's 1,350.
Okay.
Last one, Scott. 65872. That's a bad one. Never mind.
There's 55420.
Yeah, let's look at that one.
That's
That one.
similar.
It's about the same size.
Yeah.
Maybe a little smaller even.
It's 120,000.
Like it's right there on the land.
It is.
It
It
is.
is. It is.
Okay.
It's positioned properly.
Okay.
To block up Water Street.
It's not okay.
So I'm gonna move then on case ID 2021-735, account number 50592, when considering Q1 incorrect appraised market value, that we maintain the current 2021 assessed value at $96,000.
Second.
All in favor?
My turn.
Aye.
It's my turn.
It's not separate. Letters, okay.
Okay, this letter was received October 18th, which was a couple weeks ago. Account number 25194 says, please review the tape. I was told the total value would be $519,000 plus or minus. The lot value was wrong. We discussed a lot sale, 7 Kingfisher of 389,000 K. A better lot because of the new bulkhead and direction it faces. We also discussed 26 Blue Heron, a much more valuable lot due to wider canal and bay views. My lot should be valued at no more than 389,000 K.
This is somebody that came in.
Were you in
I
letter?
guess so.
Which account number?
Robert
25194.
Jackson. Thank you, Robert Jackson, 25194, Scott.
So is this the one that's requesting that you re-listen to your hearing?
Yeah.
Yeah.
Okay, well, can you pull
All
it
right,
up?
I've got the hearing ready to go. just the question is,
Okay, open.
how much of you want to hear? This is opening the hearing and I can play as much as you want, or I can try to skip to the end.
Try to skip to the end.
Hearing on case 1584, account number 25194. Who goes first?
Your opinion is the new bulkhead more valuable?
Residential cell,
No.
no, it's on the inside of the board.
Since your desire to get the prices up. Anything else, Randy?
No, no.
Okay, what's your,
So we don't have photometry in there. Those are all, yeah, sure. Mr. Jackson's property, probably at about 7. Put it on the subject property.
70. Price difference because of different lot size.
6,400 square feet. There's the one on Blue Heron.
One of them here is also.
They're all like, okay, it's actually was sort of closing. So, you went first, right?
Yeah.
Yeah. So you got closing.
All right, so.
I spent a fortune fixing that, but I still think, so.
The better lot.
503.85 and 442.
And, yeah, I think that's a better,
Okay, I'm rolling it back a
You're
little.
just too old, man. You didn't want to do it. So. That's our time. So,
503.85 and 442.
And, yeah, I think that's a better, $599.5.
Is the improvement correct?
You wouldn't go up much.
No, I'm not saying, it's just a 40-year-old, it's a 40-year-old effective, measured up against 2015, 2010, 2012, 2019. No, adjusted, yeah. Sure.
Okay. That's done. Okay, so I'm gonna make a motion then on case ID 2021-1584. Account 25194. When considering Q1 incorrect appraised market value and Q2 appraisal ratio exceeds the median level of appraisal or equity value, I move that we lower the 2021 assessed value from $677,460 down to $599,500.
Favor?
Aye.
Okay, we have 1583 and 1585 left. You have a preference, Mr. Gill?
I can see, you guys are fair enough right there, the saving from the tax.
Okay, so,
Sounds like you misheard.
so 599, 500
That's
was
what I
the
heard.
board order.
Was the board order.
Can you look at the board order and tell us what you read?
Me,
Yes.
I'm looking in the account and I'm seeing the 2021 submitted value of 599,500.
Is that the board order?
And I'm gonna pull up the board order. I just was looking in the account and I'm looking at this order, the mailed order here.
The second page, I think, third page.
And that order is for 599,500.
Okay. So then you should write an appropriate letter.
Yeah.
In response to this letter.
Yeah,
Get right on.
I agree, but it's also,
Okay.
I move on account 25194 that we maintain the board ordered value of $599,500, which we heard re-listening to the tape for this property.
Second.
All in favor?
Aye.
Okay,
Is that enough
we
for you?
should have, yes, perfect. I think that yellow one, she said you already did.
Okay. Yes, that was the one. Okay. So this one's dated October 19th, 2021, Aransas County Appraisal District. This is count.
Six, five, one, seven, seven.
Are you looking under 15576?
I'm looking for a number here. It's Dustin Renninger.
Oh, no, it's not 15.
65177. I mean, just look that up. That is Justin Renninger.
Okay.
Do you have an address?
1577.
11, no, it's here. It's 324 Club Lake Drive,
That's-
Rockport, Texas.
That's 65177.
But you didn't do this one earlier then? I didn't hear this.
No, no, we said hearing.
Yeah, not the yellow folder,
Yeah,
the yellow.
sorry.
Okay, so
It's not
this
scanned in.
is property ID 65177 from Dustin Renninger, October 19th. To whom it may concern, please find hand-delivered documents this date. Form 50284, request for confidentiality. As a state resident and U.S. citizen by law and by constitutional rights, I have a personal right to not have my personal information be made public. All personal information on file is for the sole purpose of cooperating with the appraisal district. In addition, I qualify for privacy under tax code section.
Record this.
I'm sorry.
So he wants it confidential.
Yeah, but okay, so his letter,
I'm just wondering
I got you.
if you want it on video.
Yeah, I got you.
okay, hang on, let me. Okay, so this is, let me read. Are we under original protest form?
No,
No, hang on, Let me read this. Was he a no-show?
I think so. Remember Christie said.
Get out real quick. I need to find out, make sure that this is
The original.
was Renninger a no-show originally?
He called in, and we weren't able to hear his case because he didn't have an affidavit in place.
Okay, so then as a result of that, okay, so you should start with August 26th letter that says copy.
Okay.
Earlier documents, I guess.
It's under, it says earlier documents, correspondence to and from ARB.
Just the Gmail thing.
It's in the, yeah, just below the Gmail. It's in your,
Oh, somebody think, okay. So there's something in here that I'm not seeing here.
So there's a lot in there. I just put the background. He didn't include
Okay.
all of this,
look
but
for the one that's September 24th letter that has a stamp that says October 1st.
yeah,
The
I
top
kind of
folder,
remember
Robert.
some of this.
Earlier documents? Okay.
Yeah.
Correspondence
So-
to and from the ARB.
Mhm.
So this was the letter for the 24th.
And then scroll down.
You didn't
Right
think you
there.
needed to
Okay.
provide an affidavit.
Okay, so go ahead and read this one.
This is your letter dated to Mr. Renninger on August 26, 2021. And then you can see in another letter there,
And it was,
It would be after, yeah, keep going that way.
this is a letter to grant a future hearing, is that right? That's what the request is?
So then you would keep going. And there's the next letter from the ARB.
October 7th. Read that one. We're going-
You have an October 7th letter. So you had an August letter to Mr. Renninger, then you received another letter to by Mr. Renninger that was received by October 1st, and you wrote a letter back to him. This is all the background.
Okay,
And now we are presented with, you have to go past earlier documents and you have to look to
Okay.
the October letter, 19th letter from Mr. Renninger.
which is what I started reading.
Okay,
here.
now, I'm okay with you reading that. And the reason for that is I'm going to read into the record my letter to Mr. Renninger dated October 22nd. Dear Mr. Renninger, I've received your request for confidentiality under Texas Property Tax Code 25025. And the request you check the boxes Armed Forces and Peace Officer. As an individual entitled to confidentiality under protest, it says that this is what you have to do. So I've given him that. So I'm okay with you like closing that if you want to and like hitting the mute button so you can read that out loud.
Okay.
Okay,
But I'm just gonna
Let's be
say,
safe and do that.
I'm gonna say that you've read other things into the record on the aforementioned dates already. So go ahead and close that up.
okay.
Sal, and Scott, can you hit the blinky button? What else do we have, Val, for the rest of the day?
Best Medicare,
We start with a possible future hearing.
Yes.
that's probably
That's all.
Reinecker
Yeah, I'd say it's all.
Is it?
Yeah, sorry.
Once we go over the beginning of next year, we can't hold hearings until the classes are complete, right? Didn't you test that with your lawyer
Yeah,
last year?
you'd have to schedule one before the end of the year. Otherwise, you can't do it until everybody's trained.
Until everybody's trained.
Um,
And that's a new board.
Yeah.
I'd say let's do it in November
Yeah,
or early December.
well, yeah, early December. Okay. I'm out on the 16th, 17th, 18th, that couple days before Thanksgiving. But again, I'm,
Okay.
okay,
I'm not-
so, the person that we just talked about, these are the two future hearings that you should consider to be granted. The first one deals with, I'm just gonna read, I'm not gonna read his name, but I'm gonna read the incorrect appraised market value values and unequal compared with other property. Property description is incorrect. The letter from the district dated 9/20 describes the property being 50% commercial. However, there's no evidence, no survey evidence provided. In fact, the satellite map on the file shows less than 50%. The same satellite shows incorrect property line, allowing property 26718 border 54865. They're cutting off my property 65177 or 177, which is a small section of bordering the 26719 pursuant to deed file with county clerk. State law does not restrict homestead having a business.
That was written in the letter.
That's what we just read.
Okay.
It's on agenda number 7.
And then the second one has to do with an exemption was denied, modified, or cancel. I'm in the midst of having conversations of denied the exemption. And I'm going to ask for the things that are required for a homestead exemption, which are a valid current state ID that matches the situs of the subject property. Until I receive it, I'm going to deny it. And he's welcome to protest that. You should hear that after that exchange. If I end up denying it and he still wants to protest it, or if you want to hear it right now with all the evidence that he's presented, great.
Let's do it later.
No, go do your thing.
No,
Yeah.
no, you're just saying to grant a future hearing for the exemption. So my thought is that I'm gonna have exchanges with the property owner. The law allows for that. But if at the end of the day, I deny his exemption on the last go around, he's still eligible for this. So am I authorized by this board to, if I deny it, to actually schedule, like put him on the next one? I mean, I need, you're okay for that?
Yeah, you do your thing and then we'll do it.
Okay.
Do we need a motion?
Yep. So you need a motion on both those things. One was the value question, the protest, which I think you just addressed with the last one. And the other one has to do with the exemption protest, which you should address.
Why are we addressing the value question?
Well, you can say that you addressed it in the letter that you just formulated in the last thing.
Okay,
Because he submitted 2 things on it, so.
and these are recent submissions. Okay, fine.
So the value piece is, I guess I'm confused.
Look,
Yeah, I thought we.
Show him the letter.
Yeah.
Show him the protest. There's 2 things he submitted.
Okay.
One has to do with value and incorrect appraised market value. The other one
We
has to
just
do with
addressed that one. We said no.
Okay, so we're done with that. All we need is a motion on the second. Okay.
Yeah.
Okay. So I move on property ID 65177 that as the chief appraiser continues to
Have correspondence.
and communicate with the property owner, that if the exemption is denied, modified, or canceled, and that is protested, that we allow the chief appraiser, Mike Soto, to schedule a hearing for that purpose,
For the exemption.
for the exemption question.
Aye.
Aye.
Oh my gosh, what else do we have?
Are you done?
No.
All right, the next one is discussion and possible action on the hearing procedures and items related to hearings, including setting future hearing dates for rescheduled hearings.
Do y'all really want to go over procedures right now, or do you just want to schedule the next hearing?
We're good, just schedule it.
Schedule another hearing, okay.
We
Okay,
don't have any procedures.
All right, we have a
Okay.
report on joint motions.
all right, joint motions, I'll try to make this quick. On your joint motions sheet, you have, we have one, that's good. So Mike Soto and James and Kathy Rogers are the joint motion. The account number is 66460. There was a settlement reached by the appraiser and the agent during the protest season that wasn't returned. The incorrect value is 415, 460. The correct value is 412,600. So apparently there was a settlement offer that was never signed. We still honored it. It's 412,600. All right, motion.
Okay. So I move on property ID. Where is it?
66, read that number.
66460.
Yeah.
66460, there it is, 66460, that we approve the joint motion to correct incorrect appraised value for this property owned by James and Kathy Rogers to $412,600.
Second.
All in favor?
Aye.
You just clammed up over it, didn't you?
Now we got chief.
Okay, chief appraiser motion to correct the very first one. If you'll open up the thing, is 225 Rattlesnake Point Road. That's account number 15444. There's an error of ownership for 2021. Ownership was transferred without proper paper trail showing Angela Downham had the right to transfer the property to Joe Gonzalez and Hannah Oakman. The motion will cause the property ownership to be changed back to Aunt Anita Faye Worthington, who is deceased but is the owner of record. So basically, somebody submitted a deed that says we're going from here to here to here, but there was not a clear title.
Okay,
And we kind of said, well, where is this connected? And so we changed it back.
okay.
All right, next one we have on, let's see, if this is 1413 16th Street, account number 8822179. Says the structure that existed on the ground, PID 8822179, was incorrectly included on the neighboring property. 8810441 rather than 8822179. This motion adds the structure to PID 8822179 for the 2020 year with a 50% completion value, resulting in a higher assessed value for the 2021 year. The assessed value will increase by $62,140 for the total assessed value of $85,020, an increase in the taxes due. Basically, in this situation, we had two lots out in the prairie, and we put it on this. We had them both on this parcel, and one should have been on this parcel. Okay, this is what changed. And that was 1430 16th Street. And go to the next one. This is 416 Adolfo. There's two motion to corrects. Why did I sign this twice? Oh, yeah.
One was to go the other way, right?
The other one, the other is not, whenever the tax obligation goes down, it's not like you don't need to approve it. Like I can just do it. So the other one's just falls under 2525 Bravo.
Yeah.
So I took
Motion.
the other part off the roll. All right, this one is chief appraiser motion to correct for the appraisal roll. This is 416 Adolfo clerical error that affects 2019-2020. Manufactured home and land exist on 416 Adolfo, 2 accounts. Both accounts 56711 and 88209 had a 100% homestead exemption applied. Because both accounts were not placed in a homestead group, this motion will place the accounts in a homestead group for both years, so the exemption will be split and the accounts based on the percentage value each. This will result in an increase in taxes over each years. So what happens is if you have land and you have a mobile home and they're not in a group, they're getting like a $12,500 exemption and another $12,500 exemption. They're getting twice the exemption that they should have had the homestead group been applied. So they got double the exemption that they should have gotten. That's for this account and the very next one, which is the other one that's described, which is 56711. And it basically reads the same. All right. What is this last stuff? Val? What are these notes? They're just notes for chief appraisers?
Oh, yeah.
And then this one, we decided to do it the next meeting?
Well, right, it just didn't come at that time.
Okay.
And then you have this one that doesn't need a hearing.
Okay, oh, we don't,
Do you need to read it or?
yeah, I guess so. This is the other part of the equation, Scott. On 16th Street R.
Yeah.
The structure that existed on the property value at 822-179 was incorrect. So we took it out.
Yeah, so it's one goes one way, one goes the other.
All right, motion.
Okay, I move that we accept the chief appraiser's motion for correction of appraisal roll.
Second.
Second.
Favor?
Wait, what else do we have? That's it, right?
There's no supplements, and then y'all want to talk about the next meeting.
A date for the next meeting.
Do you want us to pick and give you some? Like group text, I mean like a email?
We can send out a
Give me
group
some
email
possible.
maybe and figure it out.
Yeah, I got dates.
I know y'all are done.
Yeah.
Okay. I'd like to say that was super fun, but it wasn't. It was a long day.
Stressful.
Thank y'all very much.
I'll make a motion that we adjourn.
Yes.
Second.
What time is it, Charlie?
Aye.
6 o'clock. The latest one.
It's a full day. Hope we get paid twice.
Can we get overtime in that last hour?